Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations.
Oath or affirmation. Announcements by the Speaker.
Members, I now propose to give the two outstanding rulings on the matters of privilege. For the sake of convenience, can I, because it being the shorter one, can I crave your indulgence to rule on the one involving the member for Tancoo Sangre Grande firstly? So this is my ruling. Honorable members are now prepared to rule on the question of privilege raised by the member for Ruka Lupino at the third sitting of the House held on Wednesday, June 18, 2025. The honorable member alleged that the member for Tancoo Sangre Grande and Minister of Defense and Minister in the Ministry of Homeland Security deliberately misled the House by asserting that Senator Faris Al-Rawi was renting Agra Court to the Trinidad and Tobago Police Service. I caution all members that the privilege of freedom of speech, a most fundamental privilege enshrined in the Constitution and the norms of parliamentary procedure and practice, carries with it an equally high obligation that members should satisfy themselves of the correctness of their statement regarding members of this House or those who belong to the other place before making them. Whilst mere negligence, recklessness, or inadvertence regarding the accuracy of a statement does not meet the threshold of deliberately misleading the House, members ought to refrain from making statements which may be interpreted as seeking to cast aspersions on other members. Having regard to the personal explanation made by the honourable member for Tancoo Sangre Grande, in which he apologized for his statements and withdrew them, I am satisfied that no further action is required by the House. I so rule. Insofar as the next ruling is concerned, this is my ruling. Honourable members, at the third sitting of this first session held on Wednesday, June 18, 2025, the member for Barataria San Juan was granted leave to raise a matter of privilege in accordance with Standing Order 32. I indicated that I would give my ruling at a subsequent sitting, and I am prepared to now rule on the matter. The member alleges that the member for Diego Martin Northeast deliberately misled this House by claiming that the High Court's decision in CV 2021-01293, Rohani Ramkisoon versus the Minister of Finance, was currently under appeal, and therefore the member for Labre could not discuss the case as the matter was sub judice. The House was subsequently informed that this appeal, Civil Appeal number 268 of 2022, was struck out on Monday, February 4th, 2025. Honourable members, it is accepted that in order for an alleged incorrect statement to constitute a breach of privilege or contempt of the House, it has to be proved that the statement was not only wrong or misleading, but it was made with the intention to mislead the House. I think we would all agree that is a fairly high threshold to meet. A breach of privilege can only arise when the member makes a false statement or an incorrect statement willfully, deliberately, and knowingly. I have considered the circumstances surrounding the matters raised at the third sitting, and I have also examined the personal explanation made by the Honourable Member for Diego Martin North East. The member unreservedly apologized for his misstatement regarding the status of Civil Appeal number 268 of 2022. Moreover, the member presented a letter from the attorney with conduct of the matter, who averred that neither the member nor the senior attorney was provided with a status update on the appeal. This unfortunately, however, led the minister to assert the matter was sub judice. Honourable members, without seeking to prolong this ruling, the accepted practice is that where members make inaccurate statements and tenuously correct those statements, the House ought to accept the truthfulness of the correction. I therefore rule that having regard to the personal explanation made by the Honourable Member, in which he apologized for his statements, and the assertions in his personal explanation have been supported by a letter from a senior attorney, I am satisfied that no further action is required by the House. Honourable members, given the peculiar confluence of circumstances, it would be remiss of me not to advise members that they should think long and hard before seeking to invoke the sub judice rule. This applies even more so where the member alleging that a matter is sub judice is a party to the proceedings in question. The member has a duty to be informed of matters in which they are a party. Honourable members, I would also like to take this opportunity to provide some guidance regarding the sub judice parliamentary convention, particularly its purpose and application. The sub judice rule is a parliamentary convention which literally interpreted means under judicial consideration or before the court or judge for determination. The convention is applied to strike a meaningful, necessary, but delicate balance between the competing interests of a member's right to freedom of speech and free parliamentary discussion and the rights of parties involved in legal proceedings not to be subject to matters which may unduly influence or prejudice the outcome of their case by discussions in the Parliament. Honourable members, the sub judice rule has been codified in Standing Order 49. The essential point to be distilled from Standing Order 49 is that the sub judice rule is not absolute, but it's discretionary in its application, and in prescribed circumstances, the ultimate act of striking the delicate but necessary balance may lie in favour of discussion in the Parliament of matters which are before the court. It must be stressed that this balance and the application of the sub judice rule will be or must necessarily be conducted on a case-by-case basis on matters which are peculiar to the factual matrix of the case under consideration when the standing order with regard to sub judice is sought to be invoked by the member. And there's very good reason for that. If the sub judice convention is applied too broadly, then the mere existence of litigation can be used as a justification for curtailing and preventing and stymieing debate. Surely, this could not have been the intention of the framers of the standing orders or those who constructed the standing orders in the manner in which the standing orders have been constructed. Conversely, if the sub judice rule is applied too narrowly, members may make statements that undermine the integrity or impartiality of judicial proceedings through their pronouncements in Parliament. Honourable members, in rendering a decision whether the sub judice rule applies, I am obliged by Standing Order 49 to consider conjunctively the following factors: whether the matter is of general public importance or involves a ministerial decision. It is healthy in a democratic parliament for parliamentarians to comment on matters of public concern, which might sometimes necessarily include litigation of public concern. I hasten to add and to stress that discussions on litigation of public concern must be done in a sober, respectful manner, not calculated to engender prejudice or excite any form of undue prejudicial discussion about the case. Whether the matter is under adjudication, particularly before a jury, there is a higher risk of a jury being influenced by Parliament than a judge. David McGee, in his parliamentary practice in New Zealand, has guided that judges are not so faint-hearted that any obscure remarks made in Parliament would cause them to immediately alter the judgment they would otherwise deliver in the case before them. Such a view would be grossly insulting to the judiciary. In other words, justice must be allowed to be meted out in the clear streams of justice, to mirror the words of one of the law lords in the case of Bennett and Horseferry Magistrates Court. In this regard, the sub judice convention is more strictly applied in criminal cases than in civil cases, which are determined by a judge. I would commend all members to get a good grip of the essence of the sub judice rule and the public policy behind it, to have recourse to the celebrated judgment of Lord Diplock in Lonro and Shell PLC. Whether the comments create a real and substantial danger of prejudice to the fair determination of the matter. There is a crucial and critical difference between commenting on litigation and commenting in a manner that may improperly influence that litigation. Discussions in Parliament should not undermine the rights of parties to judicial proceedings, to a fair and impartial tribunal and a fair trial. Honourable members, I draw your attention to Standing Order 49-2 and urge you all to be judicious, balanced, and temperate when alleging that a matter is sub judice. For as the standing orders prescribe, when a member invokes the sub judice rule, he takes responsibility that the preceding subparagraphs of the standing order are satisfied. Having taken such responsibility, the member must be prepared to abide by the outcome of undertaking such responsibility. In these circumstances, I implore all honourable members of this House to responsibly use their constitutional right of freedom of speech and parliamentary discussion in a judicious, temperate, and respectful manner, and not to use the invocation of Standing Order 49 so as to impede and or stymie the right of the citizen to a fair determination of judicial proceedings. I so rule. Appointment of sessional select committees. Honourable members, pursuant to Standing Order 89-2, I have appointed the following members to serve on the session. Can I just allow Madam Prime Minister to take her seat? I will. as I was reading earlier, honorable members, pursuant to Standing Order 89-2, I have appointed the following members to serve on the sessional select committees of the House of Representatives for the first session, 13th Parliament. Standing Orders Committee, Jagdev Singh, Chairman, Mr. Saddam Hosein, Mr. Wilfred Nicholas Morris, Dr. Richard Sicharan, Mr. Marvin Gonzalez, Mr. Colm Imbert as members. House Committee, Mr. Barry Padarat, Chairman, Mr. David Lee, Mr. Wilfred Nicholas Morris, Dr. Aina Ali, Mr. Marvin Gonzalez, and Mr. Colm Imbert as members. Committee of Privileges, Jagdev Singh, Chairman, Mr. Barry Padarat, Mr. Saddam Hussain, Mr. Devesh Maharaj, Mr. Stuart Young, Senior Counsel, Mr. Keith Scotland, Senior Counsel, members. Statutory Instruments Committee, Chairman Jagdev Singh, members Mr. Hansen Narayan Singh, Dr. Narendra Rup Narayan, Dr. Colin Neil Gosain, Mr. Keith Scotland, Senior Counsel, and Mr. Kareem Marcel. Business Committee, Chairman Jagdev Singh, members Mr. Barry Padarat, Mr. Davendranath Tancoo, Mr. David Lee, Mr. Dominic Romaine, and Dr. Nyan Gadsby-Dolly, members. Leader of the House.
Thank you. Mr. Speaker, I beg to move that the following 4 members
My apologies. I'm advised by the learned clerk that this part of it comes later in the proceedings. It's intended to be dealt with later in the proceedings.
Bills brought from the Senate, petitions, papers.
Minister of Finance.
Thank you, Mr. Speaker. Mr. Speaker, I have the honor to lay the following papers standing in my name. 1. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Princestown Regional Corporation Chairman's Fund account for the year ended September 30th, 2021. 2. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Princestown Regional Corporation's Chairman Fund for the year ended September 30th, 2022. And 3. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Office of Procurement Regulation for the year ended September 30th, 2023. Mr. Speaker, I beg to move that papers 1 to 3 be referred to the Public Accounts Committee.
Honourable members, the question is that papers 1 to 3 be referred to the Public Accounts Committee. All in favour say aye. Aye. Any against? The ayes have it.
Reports from committees, Prime Minister's questions, urgent questions.
Member for Arima.
Thank you kindly, Mr. Speaker. Mr. Speaker, to the Honourable Minister of Works and Infrastructure, can the Minister indicate what actions is being taken to expedite the restoration of the North Coast Road to Brasso Seco, which suddenly collapsed on Thursday and has led to the complete isolation of the village? Thank you, Mr. Speaker.
Minister of Works.
Yes. Well, the erosion of that Brasso Seco North Coast Road has been under the view of the Ministry of Works for quite some time. And in this instance, this sudden and dramatic collapse, the intention is to install a Bailey Bridge in the short term, the installation will take about 10 days.
You kindly, Honourable Minister, is it possible to indicate when they are likely to start?
Immediately.
Thank you, Honourable Minister.
Member for Diego Martin Northeast.
Thank you, Mr. Speaker. To the Minister of Finance, can the Minister provide the reasons for the termination of the appointment of Dr. Alvin Hilaire as Governor of the Central Bank of Trinidad and Tobago?
Minister of Finance.
Thank you, Mr. Speaker. Mr. Speaker, I refer your attention to Standing Order 27(1)G as it relates to this question.
Member for Diego Martin, the Minister, in his opinion, I'm mirroring the words of the standing order, is invoking Standing Order 27(1)G, which says a minister may decline to answer a question if, in his opinion, the publication of the answer would be contrary to the public interest. Member for Ruka Lopino.
To the Minister of Public Utilities, in light of the confirmation by the Board of Commissioners of the Water and Sewage Authority of the immediate termination of 9 executive officers of WASA, can the Minister indicate the reasons for the termination?
Minister of Public Utilities.
Thank you kindly, Honourable Speaker. Mr. Speaker, I refer your attention to Standing Order 27(1)G as it relates to this question.
(27)(1)G, member, is the minister invoking the public interest exemption in relation to that question.
Questions on notice. Request for leave to move the adjournment of the House on definite matters of urgent public importance. Statement by ministers. Personal explanations. Introduction of bills. Motions relating to the business or sittings of the House and moved by a minister.
Leader of the House.
Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Finance and Legal Affairs. Mr. Devesh Maharaj, member. Mr. Sean Sobers, member. Dr. Rishad Sicharan, member. Mr. Brian Manning, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Finance and Legal Affairs. Mr. Devesh Maharaj, member. Mr. Sean Sobers, member. Dr. Rishad Sicharan, member. Mr. Brian Manning, member. All in favour, say aye. Aye. Any against? The ayes have it. Leader of the House.
Mr. Speaker, thank you kindly. I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Land and Physical Infrastructure. Mr. Speaker, those members are Mr. David Lee, member, Mr. Saddam Hosein, member, Dr. Michael Dowlat, member, Mr. Christian Birchwood, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Land and Physical Infrastructure. Mr. David Lee, member, Mr. Saddam Hosein, member, Dr. Michael Dowlath, member, and Mr. Christian Birchwood, member. All in favor, say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Social Services and Public Administration. Ms. Khadija Amin, member. Dr. Michael Dowlath, member. Mr. Sean Sobers, member. Mr. Simon De Nobrega, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Social Services and Public Administration. Ms. Khadija Amin, member. Dr. Michael Dowlath, member. Mr. Sean Sobers, member. And Mr. Simon De Nobrega, member. All in favor, say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Local Authorities, Service Commissions, and Statutory Authorities. Ms. Vandana Mohit, member. Ms. Michelle Benjamin, member. Mr. David Thomas, member. Mr. Kareem Marcel, member.
Honourable members, beg your pardon. The question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Local Authorities, Service Commissions, and Statutory Authorities. Ms. Vandana Mohit, member. Ms. Michelle Benjamin, member. Mr. David Thomas, member. And Mr. Kareem Marcel, member. All in favor, say aye. Aye. Any against? The ayes have it. Leader of the House.
Mr. Speaker, thank you kindly. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on State Enterprises. Mr. Barry Padarat, member. Mr. Philip Watts, member. Mrs. Shivana Sam, member. Mr. Marvin Gonzalez, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on State Enterprises. 1, Mr. Barry Padarat, member. 2, Mr. Philip Watts, member. 3, Mrs. Shivana Sam, member. And 4, Mr. Marvin Gonzalez, member. All in favor, say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Human Rights, Equality, and Diversity. Mr. Barry Padarat, member. Dr. Lackram Bodoe, member. Mr. Ernesto Quezar, member. Dr. Nyan Gadsby-Dolly, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Human Rights, Equality, and Diversity. Mr. Barry Padarat, member. Dr. Lackram Bodoe, member. Mr. Ernesto Quezar, member. And Dr. Nyan Gadsby-Dolly, member. All in favor, say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Foreign Affairs. Mr. Davendranath Tancoo, member. Mr. Wayne Sturge, member. Mr. Clyde Elder, member. Mr. Simon De Nobrega, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Foreign Affairs. Mr. Davendranath Tancoo, member. Mr. Wayne Sturge, member, Mr. Clyde Eller, member, and Mr. Simon de Nobrega, member. All in favor, say aye. Any against? The ayes have it. Leader of Government Business.
Thank you kindly, Mr. Speaker. Mr. Speaker, I move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Energy Affairs. Ms. Jerlene John, member. Mr. David Lee, member. Mr. Wilfred Nicholas Morris, member. Mr. Stuart Young, SC, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Energy Affairs. Ms. Jerlene John, member. Mr. David Lee, member. Mr. Wilfred Nicholas Morris, member. And Mr. Stuart Young, Senior Council member. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on National Security. Dr. Rudal Munilal, member. Mr. Saddam Hosein, member. Mr. Clyde Elder, member. Mr. Keith Scotland, SC, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on National Security. Dr. Rudal Munilal, member. Mr. Saddam Hussein, member. Mr. Clyde Eller, member. And Mr. Keith Scotland, Senior Council member. All those in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Public Accounts Committee. Ms. Jerlene John, member. Mr. David Lee, member. Mr. Hanson Narayan Singh, member. Mr. Colm Imbert, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Public Accounts Committee. Ms. Jerlene John, member. Mr. David Lee, member. Mr. Hanson Narayan Singh, member. And Mr. Colm Imbert, member. All those in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Public Accounts Enterprises Committee. Dr. Rudal Munilal, member. Ms. Khadija Amin, member. Dr. Rashad Sicharan, member. Mr. Colm Imbert, member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Public Accounts Enterprises Committee. Dr. Rudal Munilal, member. Ms. Khadija Amin, member. Dr. Rashad Sicharan, member. And Mr. Colm Imbert, member. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 5 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Public Administration and Appropriations. Mr. Jagdev Singh, Chairman. Ms. Jerlene John, member. Mr. Roger Alexander, member. Mr. Devesh Maharaj, member. Mrs. Camille Robinson Regis, member.
Honourable members, the question is that the following 5 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Public Administration and Appropriations. Mr. Jagdev Singh, Chairman. Ms. Jerlene John, member. Mr. Roger Alexander, member. Mr. Devesh Maharaj, member. And Mrs. Camille Robinson Regis, member. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Parliamentary Broadcasting. Mr. Jagdev Singh, Chairman. Ms. Khadija Amin, Member. Ms. Michelle Benjamin, Member. Mr. Hans Devines, Member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Parliamentary Broadcasting. Mr. Jagdev Singh, Chairman. Ms. Khadija Amin, Member. Ms. Michelle Benjamin, Member. And Mr. Hans Devines, Member. All in favour, say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Government Assurances. Mr. Jagdev Singh, Chairman. Mr. Davendranath Tancoo, Member. Mrs. Shivana Sam, Member. Mr. Dominic Rumeen, Member.
Honourable members, the question is that the following 4 members be appointed to serve with an equal number from the Senate on the Joint Select Committee on Government Assurances. Mr. Jagdev Singh, Chairman. Mr. Davendranath Tancoo, Member. Mrs. Shivana Sam, Member. Mr. Dominic Rumeen, Member. All in favour, say aye. Aye. Any against? The ayes have it.
Business, government business, bills, second reading.
Minister of Finance.
Thank you very much, Mr. Speaker. Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251, be now read a second time. Mr. Speaker, before you is the Prime Minister's Pension Act Amendment Bill 2025, aimed at introducing a requirement that a person is required to serve at least 1 year as Prime Minister in order to qualify for a Prime Minister's pension. The bill also seeks to introduce a 4-tiered system of meritocracy, whereby the maximum benefits of pension are earned rather than bestowed for an individual serving for 4 years or more as Prime Minister. Mr. Speaker, this bill has retroactive effect from March 10, 2025. It requires a special majority of 3/5, but seeks to address a serious fallacy perpetuated on the good people of Trinidad and Tobago. Mr. Speaker, before I go much further, I want to commend the Honourable Prime Minister and the Cabinet of the Republic of Trinidad and Tobago for its vision to which we all subscribe, that public officials are meant to serve the public and not just themselves. For far too long, Mr. Speaker, for far too long, public officials on the other side have been busy serving themselves. And today, this government, of which I am proud to be part of, led by the Honourable Kamla Prasad-Bissessar, is standing in the gap for the people of Trinidad and Tobago. Today, Mr. Speaker, we will see who stands in defense of the people of Trinidad and Tobago at a time when mothers are crying out for help for their children, and when the country, Mr. Speaker, is in need of support. Mr. Speaker, today, the country will be paying close attention to all elected and unelected members of Parliament to see how they stand in support of the people of Trinidad and Tobago. Mr. Speaker, recently we witnessed actions in this country that were very likely, Mr. Speaker, undemocratic, and which resulted in a prime minister that no one wanted, and one which this country subsequently downright fully rejected. Mr. Speaker, when the Member of Parliament for Port of Spain North, St. Anne's West became Prime Minister on April 17, 2025, what did he do? What was his first act, Mr. Speaker? Mr. Speaker, the member of Port of Spain North, St. Anne's West, his first act, he moved to dissolve the Parliament, and by the time Parliament was dissolved by proclamation published as Legal Notice number 98 of 2025 on March 18, 2025, just one day after the member for Port of Spain North, St. Anne's West became an unelected Prime Minister, the country was advised of a snap election. Perhaps, Mr. Speaker, the Member of Parliament for Port of Spain North, St. Anne's West counted on the possibility that when the election bell was rung, that there would be no more attention to himself as the unelected Prime Minister. Clearly, he ought to have known, Mr. Speaker, that these actions would undermine the essence and intent of the Constitution of the Republic of Trinidad and Tobago. But you see, Mr. Speaker, he was wrong, and this is why I will always have faith and confidence in the good people of Trinidad and Tobago. Mr. Speaker, not only was he wrong, but we are here today to right the wrong that was thrusted upon the population of our beloved country. What I placed on the record in Parliament today, Mr. Speaker, may sound like a conspiracy theory, only because it is so shocking and offensive. But, Mr. Speaker, every part of it is true. And we must therefore accept that it is highly arguable that the Honourable Member for Port of Spain North, St. Anne's West was never eligible to be appointed as Prime Minister by Her Excellency pursuant to Section 76(1)(a) of the Constitution. Mr. Speaker, in short, that appointment as Prime Minister is most likely unconstitutional. But even if it were constitutional, I believe that the Act should be brought in line with regional best practice and our own legislative provisions. Mr. Speaker, this particular instance and others alienated the last government from the people, Mr. Speaker. What this government has decided to do as a result is to turn lemons into lemonade. This fiasco, Mr. Speaker, has allowed this government, our government, to bring forward meaningful legislative reform to amend the Prime Minister's Pension Act, Chapter 251, that has been overlooked for many years. At this stage, Mr. Speaker, I want to make a few more points that I'm sure others on this side will expound further on as they touch and concern the constitutionality issue. Mr. Speaker, firstly, I want to make it very clear that this bill is not ad hominem in nature. It is meant to apply to every person appointed as Prime Minister with immediate effect. It clearly has retrospective effect in the sense that if a person is not eligible under the Act, no pension is payable to him. Mr. Speaker, this bill before you serves to implement legitimate area of reform. The introduction of a minimum mandatory period of service by the Prime Minister to gain a pension via a tiered system of meritocracy. When one looks at the landscape, Mr. Speaker, of the pension laws in Trinidad and Tobago, one would see that almost all offices have a minimum period stated in law for which one must fulfill to qualify for a pension. Members of Parliament, for example, Section 5(1)(a) of the Retiring Allowances Legislative Service Act requires a period of not less than 5 years. Diplomats under Section 7(1)(a) of the Retiring Allowances Diplomatic Services Act requires a period of not less than 8 years. Public servants, Regulation 2 of the Pensions Regulations, require a period of 10 years or upwards. Teachers, Regulation 4 of the Teachers' Pensions Regulations, require a period of 10 years or upwards. Police, Regulation 185 of the Police Service Regulations, requires a period of not less than 10 years, Mr. Speaker. Fire, Paragraph 3(4) of the 5th Schedule to the Fire Service Act provides a requirement of a period of not less than 10 years. Mr. Speaker, as such, I put it to the Honourable House that the proposal for reform as contained in this bill is neither sinister nor ad hominem. It is the result of a genuine need for reform that has arisen, albeit on a set of very peculiar and unfortunate facts that ought not to have existed in the very first place. Mr. Speaker, what is good for the goose is good for the gander. And what is good for the goose and for the gander is good for all. Mr. Speaker, going even further, the population may ask the very real and sensible question: is there any precedent for what this government is seeking to do anywhere in the world? Mr. Speaker, the simple answer to that question is yes, and we can find examples right here in the Caribbean, Mr. Speaker. Antigua and Barbuda. Mr. Speaker, in Antigua and Barbuda, a Prime Minister's pension is paid in accordance with the Pensions and Gratuities Parliamentary and Special Officers Act, Chapter 322. Mr. Speaker, Section 3 of that Act states that, and I quote, "Every person who, having held office of Prime Minister on or after the 27th day of February 1967 for one full parliamentary term or for periods equal in aggregate to 5 years, ceases at any time thereafter to be Prime Minister, shall be paid a pension under this Act with effect from the date on which he ceases to be Prime Minister, and subject to subsection 2 and section 16 of such pension, will continue to be paid during the lifetime of that person." There is precedent, Mr. Speaker, but there's more. There's more. If we turn next to the Bahamas, a Prime Minister's pension is paid in accordance with the Prime Minister's Pension Act. Again, Section 3 of that Act states, "Every person who, having held the office of Prime Minister on or after the coming into operation of this Act, ceases at any time thereafter to be Prime Minister and has served as a Prime Minister for at least 8 years, shall be granted a gratuity equivalent to the annual basic salary, and b, an annual pension equivalent to the annual basic salary then payable to him at the date of his ceasing to be Prime Minister." This is Bahamas. This is in the Bahamas. I referenced Antigua and Barbuda just recently. We had a similar provision, Mr. Speaker. So therefore, Mr. Speaker, when this government seeks to introduce a period of at least 1 year's service from the date of appointment as Prime Minister for a person to be eligible to receive a pension, that is a very balanced approach, Mr. Speaker. Mr. Speaker, I now turn to the bill at hand, which consists of merely 6 very important clauses. Mr. Speaker, Clause 1, the short title. Clause 1 of the bill contains the short title, cited as the Prime Minister's Pension Amendment Act 2025, which is straightforward and requires absolutely no explanation. Clause 2, the commencement clause. Clause 2 of the bill seeks to establish March 10th, 2025 as the effective date of the bill. Mr. Speaker, this ensures that the bill has retroactive effect, and because of this, the government is being cautious and ensuring that it is passed with a special majority. Clause 3. Mr. Speaker, I know that the members on this side will later expound on the constitutionality issue as it arises in the bill. However, Clause 3 contains the required statement that the Act as presented is inconsistent with the Constitution. Again, this arises owing to the retroactive nature of the bill, but it is rarely being included out of an abundance of caution. Clause 4, Mr. Speaker, is the interpretation clause and simply references the phrase, the Act, to mean the Prime Minister's Pension Act. I turn now to Clause 5, Mr. Speaker. Clause 5 of the bill amends Section 3.1 of the Prime Minister's Pension Act to introduce a requirement that a person is required to serve at least 1 year as Prime Minister in order to qualify for a Prime Minister's pension. Mr. Speaker, this is done by inserting the words 1 year from the date of in Section 3.1 as follows. So this is what the new Section 3.1 will read. 3.1. Every person who has been appointed Prime Minister on or after the 31st day of August 1962 and ceases at any time after, and this is the insertion, 1 year from the date of such appointment to be Prime Minister shall be paid a pension under this Act with the date effective on which he ceases to be Prime Minister, and subject to subsection 2, the pension shall continue to be paid during the lifetime of that person. Mr. Speaker, the last clause, Clause 6, introduces a tiered system of meritocracy, where the longer a Prime Minister has served, the more benefit he or she receives in relation to the pension. Mr. Speaker, for the benefit of the viewing and listening audience, this simply means that where an individual has served as Prime Minister for not less than 1 year but more than 2 years, a pension of 1/3 of the highest annual rate of salary paid as Prime Minister. Where that person in Prime Minister has served for not less than 2 years but not more than 3 years, a pension of 1/2 of the highest annual rate of salary paid as Prime Minister. And, Mr. Speaker, in the circumstances where a Prime Minister would have served for not less than 3 years, but not more than 4 years, a pension of 3/4 of the highest annual rate of salary shall be paid as a pension to the Prime Minister. And finally, Mr. Speaker, where the circumstance is that a Prime Minister has served for not less than 4 years, but not more than 5 years, a pension of the full amount of the highest annual rate of salary shall be paid as Prime Minister. Mr. Speaker, this government is of the view I am absolutely reminded that a member of this Honourable House, not one member of this Honourable House, will be left penniless as a result of the passage of this legislation by this House. The provisions, Mr. Speaker, in our view, this tiered system is fair, just, and equitable. A characteristic which fully defines this government on this side. Mr. Speaker, it provides a clear and transparent manner for the Prime Minister to earn the justifiable and proportionate pension that is allocated on the basis of service. Meritocracy, Mr. Speaker. It is consistent with other pension laws in Trinidad and Tobago and elsewhere in the Caribbean region, as I just indicated. And through this scenario, though this scenario, Mr. Speaker, should have never existed in the first place, it has permitted the opportunity. It has permitted the opportunity for this government to seek genuine reform. Mr. Speaker, with those few words, I commend the bill to the House, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251, be now read a second time. Member for Diego Martin Northeast.
Thank you, Mr. Speaker. Mr. Speaker, I notice that Mr. Speaker, I'm being disturbed by the Prime Minister.
Okay, can we allow the member to continue in private? But I would have thought an experienced parliamentarian like you would have had able to brush off that. Come on, let's carry on.
Mr. Speaker, it is not a question of
stop
brushing.
gilding the lily now. Let's move on.
Brushing off anything. Mr. Speaker, the Minister of Finance skirted around the whole issue of the target of this legislation. Said a few times that this is not ad hominem legislation. Cited no law, produced no precedent, made no argument of any kind. In fact, made a fallacious argument that this will now apply to prime ministers going forward. But the fact of the matter is, Mr. Speaker, the issue with this bill, and the members opposite are well aware, is that it is retroactive. It goes back to March 10th, 2025. And there is only one person who could possibly be affected by this retroactivity, that retroactive clause. Now, I think it's necessary for members opposite to understand why this is ad hominem legislation. And the best way to do that is to look at a particular Privy Council decision of which members opposite are very familiar. And that Privy Council decision was in 2016, UK PC2, Privy Council Appeal number 0014, 0015, and 0016 of 2015. And the title of the case is Steve Ferguson Appellant versus the Attorney General of Trinidad and Tobago Respondent. Maritime Life, Caribbean Limited, and others versus the Attorney General. Amiridu versus the Attorney General. And this is an appeal from the Court of Appeal. The judgment was given, Mr. Speaker, on the 25th of January 2016. And in this particular case, these appellants were of the view that the repeal of Section 34 was ad hominem and should be struck down. Now, Section 34, of course, was a disgraceful period in our history where members opposite brought legislation to pardon persons who...
Member, I'll ask you to correct that. That is a misdescription.
Beg your pardon?
Legislation to pardon is a misdescription. You could perhaps use the correct term for what it is. If you're going to say what the legislation purported to do, then a pardon carries a specific legal meaning. I'm not stopping you from saying what the legislation purported to do, but to describe the legislation as a legislative pardon is somewhat misleading and misdescriptive of the legislation.
Sure, Mr. Speaker. I will read what Lord Sumter said, the way he described it. This appeal arises out of an ill-fated attempt to introduce a statutory limitation period for criminal prosecutions in Trinidad and Tobago. And this matter was brought to this Parliament and passed by members opposite in order to do exactly that, to introduce a statutory limitation period for criminal prosecutions, which would have the effect of persons who were outside the limitation period escaping prosecution. Okay? And there was such outrage in Trinidad and Tobago at this act of the UNC government that it resulted in a protest involving over 20,000 persons, including the trade union movement, including those trade unions from whence the member for Labrie and Point Fortin have come. And the persons who were involved went to court and took it all the way to the Privy Council. And it's important to look at what the Privy Council said, because it gives us the learning on what is ad hominem legislation. This case, more than any other. Now, Mr. Speaker, the appellants argued that the repeal legislation was designed specifically to target them. And this is what the Privy Council had to say. Mr. Speaker, I am being disturbed by the Prime Minister. I keep hearing muttering from over there. I beg your protection. As seasoned as I am, when a Prime Minister interrupts me, it is an interruption. I beg your protection.
All right, continue. The House is quiet. Let us not have such thin skins. Let us move on.
Thank you, Mr. Speaker. In this particular case, the Privy Council looked at the whole question of legislation of general application versus legislation of specific application. The appellants argued that the repeal of Section 34 was specifically designed to target them. The Privy Council ruled otherwise. The Privy Council indicated that the legislation, the repeal legislation, would affect everybody whose prosecution was to be limited by the previous legislation. The Privy Council found that it was not specific because it affected a wide group of persons. It wasn't just these people who would have been affected adversely by the repeal legislation, but everybody who was outside of the limiting period. It is as simple as that, Mr. Speaker. So what the Privy Council found in the Steve Ferguson case was that it was not of specific application. But what about this? What does this bill do? This bill is targeted at a single individual. It is not a group of people. It is not a class of people. It is one person. And therefore, based on the dicta in the Steve Ferguson matter, this is ad hominem legislation. The members opposite could jump high and jump low, but the fact of the matter is that there's only one person, one, who could possibly be affected by the retroactive clause. Nobody else. No former Prime Minister, other than that single individual that this is targeting, can be affected by the... Mr. Speaker, really?
Yeah. Let the member continue, please.
Mr. Speaker, I know he can't help it, you know. I know he can't help it.
Complain and then you contribute. I mean, that is inconsistent. Come on, let's carry on.
Mr. Speaker, I'm not sure what I'm contributing to. I'm stating a fact. But the fact of the matter is, the Privy Council was very, very, very clear in this particular matter. Very, very, very clear. That if legislation is specific, if it targets on a plain reading, an ordinary meaning of, if it targets a single individual or a small group of people, then it is ad hominem. And I am certain that if this is tested in the court, and I heard the, what do they call it, the fallback? I don't know what to call it. I heard the fallback argument or the escape argument as well. They want to fall back on a theory that the appointment of the person that this legislation is targeted at was not properly appointed as Prime Minister. I heard that in the vague utterances of the Minister of Finance. So when they lose on the ad hominem part, they want to go to the Constitution and say that it was unconstitutional for the particular individual to be appointed as Prime Minister. Well, I wish them luck with that. And if they're so sure about that, why didn't they challenge it? Why didn't they challenge the constitutionality of the appointment of that particular individual? They didn't. You know why? Because they're not very sure about that point. We are quite sure that the appointment was correct. So, Mr. Speaker, what's really going on here? The Minister of Finance gave us a story which is incomplete and inaccurate. Said that it is best practice in the region. That's not true. In Jamaica, under the Prime Minister's Pension Act, there is no qualifying time. There is no qualifying age. In Jamaica, a person could serve as Prime Minister for 5 seconds. They could be 20 years old and they qualify for a Prime Minister's pension. The Minister of Finance didn't say that. In Barbados, it is exactly the same thing. A person can serve as Prime Minister for 5 seconds and can be 20 years old and would be eligible for a pension. So I do wish that the Minister of Finance had given us the complete picture. There is absolutely no doubt, that around the world it differs. I noticed the Minister of Finance ran away from India, which has the same similar provision. No qualifying period in India. So the practice all over the world is different. Yes, it is true that in Antigua and Bahamas there is a qualifying period. That is a fact. It is also so in quite a few Commonwealth countries. There are qualifying periods. But it is not so in some of the major territories of the Caribbean, as the Minister of Finance would have us believe. It is not so in India, which is the largest, most populated member of the Commonwealth. So it is necessary to put these facts into the public domain. Mr. Speaker, I also notice that this government is not engaged in a creeping dictatorship. It's engaged in a galloping dictatorship. This morning, today, I understand that all CPEP contractors, all 300 of them, I believe is the number, Some number like that? 11,000? How many? People. 10,000. Over 10,000 people have been put on the breadline by
Mr.
this
Speaker,
wicked and shameless government.
48-1.
That is wholly and extraordinarily irrelevant to the issue which is before the House.
Mr. Speaker, I can't challenge the Speaker, the presiding officer.
I'm happy you're aware
I can't
of
challenge
that,
your
so
ruling.
please let us move on.
But, Mr. Speaker, this legislation is evidence of a galloping dictatorship. They fire the governor of the central bank. They fire all the managers at WASA. They fire all the CPEP contractors.
The bill before, and can I please give my ruling? The bill before the House has nothing to do with the termination of contracts, workers, employees, or anything of the sort. Okay, can I please be allowed to give this ruling in some measure of silence? So I am going to rule that those statements irrelevant, and can we move on, please?
Mr. Speaker, I do not consider it irrelevant that you are depriving someone of income by this legislation. I do not consider it irrelevant that the deprivation of income is across the board in Trinidad and Tobago under this government. That is not irrelevant.
Deprivation of income is an entirely different matter. And for the last time, please, member, I am telling you, and I don't mean it in any particular way, please, let's move on. We're spending way too much time on a matter that I have ruled 3 times irrelevant. Let's move on, please.
Mr. Speaker, if this is how it's going to be, okay, all right, I have to abide by your ruling. I have to abide by your ruling. This legislation, I will say it for the last time, according to the Steve Ferguson decision of the Privy Council, is the most ad hominem piece of legislation I've ever seen in my life, probably in the world. It is intended to deprive somebody of property as they are depriving thousands of people of property. I beg to move.
Secretary Sandra.
Thank you very much, Mr. Speaker. No amount of shouting or screaming, you will get your way today. And your days for begging to move is over. Because the people moved you out. But interestingly, Mr. Speaker, the member spent about 10 minutes in his contribution. That's all he used. Short contribution. And said that the legislation is ad hominem. For those who are listening to us, it means ad hominem. It applies to a particular group or person or so on. But the member did not name the person. I am still, all of us on the side, we don't know who he was speaking of. Who is the legislation ad hominem to? In fact, when you look at the legislation, Mr. Speaker, it is a general legislation that applies to all prime ministers who will be entitled to a pension. But you see the member probably suffering from a little tabanca. Because that member, Mr. Speaker, acted about 50 times as the Prime Minister. I believe the Honorable Prime Minister gave him an Oscar for the Best Actor. And he will never be Prime Minister of Trinidad and Tobago.
Come on, 48-1. I was relevant as far as I'm concerned. 48-1.
Yes, member for Maharaj. Let's move on a bit.
Thank you very much, Mr. Speaker. Mr. Speaker, on careful consideration of the bill before this House, this bill is lawful, that's right. It is proportional, and it is reasonably justifiable in a democratic society. That's right. We gave a commitment, Mr. Speaker, that we will protect the public's interest, and we are protecting the public's interest. But you see, this opposition, Mr. Speaker, is the weakest opposition in the history of our country. They're weak. They have lost their way. And I didn't say that. It's the member for Arima who said that. I expected, Mr. Speaker, for the member for Diego Martin Northeast to tell us whether they support the bill or not. 41 of us were called to this parliament today, Friday, 27th of June, 2025, to discuss a matter relating to the head of our government. And we had to learn through Facebook, Mr. Speaker, that one member from that side not coming. In fact, I have been here for some time, and if you don't come, you ask the Speaker for leave of absence. To go on Facebook and tell the Speaker of the House that the member is not coming is contemptuous. It's disrespectful.
Mr. Speaker,
it's absolutely disrespectful.
A point of order, Mr. Speaker.
Member, withdraw that description.
I withdraw, Mr. Speaker. But, Mr. Speaker, what I want to say also on this particular matter is that we are calling on the opposition to do the right thing. Do the right thing. Please do the moral and right thing, Mr. Speaker, because it's the right thing to do. You know, Mr. Speaker, they don't know themselves if they're supporting this bill or not. I read the Newsday this morning, and I'm quoting from the Newsday, Mr. Speaker, in an article saying, House debates bill to curb Prime Minister's pension, and I quote, Opposition Chief Whip Marvin Gonzalez via WhatsApp told Newsday, I quote, we are having a caucus tomorrow to finalize our position. So they don't know whether or not they're supporting the bill or not. And that is why we are saying that they have lost their way. We agree with the member for Arima, they have lost their way. And the member for Diego Martin Northeast said something that is totally incorrect. Now, he always says a lot of wrong things, Mr. Speaker. Nobody is going to be deprived of an income. Absolutely nobody. Nobody will be left penniless, but I think some of them may want to be left penniless. But, Mr. Speaker, I want to get down to some of the issues with respect to what the member raised. And I will explain that position, Mr. Speaker, that nobody will be left penniless is because when you look at the drafting of the bill, Mr. Speaker, the bill says the conditions set out to get a Prime Minister's pension, I can give you what the law exists, is that immediately on ceasing to be the Prime Minister, you are entitled to the Prime Minister's pension, and you are entitled to the rate of the pension, which is the salary of the office holder. What we are proposing in the legislation, Mr. Speaker, is that the person must have served in the office for at least 1 year in order to become eligible for the pension. Secondly, the pension is now prorated on the length of service. If a member has not served for the 1 year in order to be entitled to a pension, but the member may have served in the cabinet as a minister or a legislator as defined by the law, which is an MP, who is elected, that person will be entitled to a pension under the Retiring Allowance Legislative Services Act. So it is totally misleading for the member for Diego Martin Northeast to say that people will be deprived of an income. That is totally wrong. Totally wrong. But, Mr. Speaker, we understand that the role of a Prime Minister is an important one, an exceedingly important role, because it guides the policy of the country. It guides the future, the direction of a country. And that is why the member of Siparia was able to become the Prime Minister twice, Mr. Speaker. Because the people of Trinidad and Tobago entrusted that particular sacred duty on the member for Siparia because they trusted her leadership, Mr. Speaker. And in all other Prime Ministers, Mr. Speaker, it is a role where there's tremendous sacrifice. Tremendous sacrifice. You may not have the best of friends, because sometimes when you become the Prime Minister, you have convenient friends. You may lose the right to privacy, Mr. Speaker. They will have cameras set up outside of your home. They will reach with tires in front of your gate, Mr. Speaker, to protest. So the Prime Minister, or the person who chooses to be Prime Minister, really has an important role. And we on the side are not saying that you deny that office holder of a pension. We are saying that the pension must be reasonable. That's what we are saying. It must be reasonable, Mr. Speaker. It must be proportionate. Mr. Speaker, with respect to the retroactive issue that the member for Diego Martin Northeast raised, and he often boasts that he does a lot of research. Well, I feel today, Mr. Speaker, my research is better than his. Mr. Speaker, we are amending what we call the Prime Minister's Pension Act. This is the Act 23 of 1969. 1969. Mr. Speaker, do you know the parent legislation operated retroactively? The parent legislation operated retroactively. Because when you read Section 3 of the Act, it says this. It says every person who having been appointed Prime Minister on or after the 31st day of August 1962 ceases at any time after such appointment to be Prime Minister shall be paid a pension under this Act with effect from the date on which he ceases to be Prime Minister, and subject to subsection 2, the pension shall continue to be paid during the lifetime of that person. So the Act was passed when? 1969, commenced on the 23rd of July 1969, but it applied to the office holder from the 31st of August 1962. It was retroactive. So what we are doing here is not wrong. The Parent Act itself operated retroactively. The Parent Act operated retroactively, Mr. Speaker, but they don't do research. A lazy opposition, Mr. Speaker. Lazy. But we must contextualize this, Mr. Speaker. I know you like context. And, Mr. Speaker, I am not bringing you into this debate. I'll never attempt to do that, Mr. Speaker. But we must look at the timing. In 1969, there was independence in 1962. We had a Prime Minister, Dr. Eric Williams. But in 1969 to 1970, there was some uprising in the country. That's right. There was the Black Power movement in 1970, but it was progressing during the year 1969. That is why the then Prime Minister ran to the Parliament to now establish the Prime Minister's Pension Act, so that if he was removed in office because of the 1970 incident, he will be well taken care of, Mr. Speaker. So that is the history that was ingrained in the PNM since then, but a UNC government will correct the wrongs of the past, Mr. Speaker. We will correct the wrongs of the past. That is why the people elected us to be here resoundingly. Now, Mr. Speaker, when we look at the entitlement of a Prime Minister's pension, all that has to happen is that the person must cease to become Prime Minister. Okay? He can cease to become Prime Minister because he resigns. We saw that recently, by death, by virtue of illness, or if a motion of no confidence is passed in this House, he has no choice but to either resign or dissolve the Parliament. He ceases to become Prime Minister. So that triggers the entitlement to the pension. Is there an age limit, Mr. Speaker? No. A Prime Minister can be any age and will be entitled to the pension. What is the rate that the Prime Minister is paid the pension? According to the existing law, he is paid at the office holder's rate. And I want to give you what that rate is, Mr. Speaker, because that is important. That is important, Mr. Speaker. When you look at the 120th report of the SRC report at page 3, the salary of the Prime Minister is $87,847. So that will be what the pension will be, Mr. Speaker. So when you look at that, Mr. Speaker, that is the entitlement what he has. What we are changing is this. We are saying in the bill, which is proportional, that if the office holder serves for not less than 1 year from the date of his appointment, he'll be given 1/3 of the highest annual rate of salary. What's wrong with that? If he serves not less than 2 years from the date of his appointment, he is entitled to 1/2 of the highest rate salary. What is wrong with that? If the person serves not less than 3 years from the date of the appointment, 2/3 of the annual salary, what is wrong with that? And if he serves for not less than 4 years, which is really the full term, Mr. Speaker, he will be given the full amount. What is wrong with that? What is wrong with this particular prescription that the opposition cannot seem to tell us if they're supporting or not? What they want, Mr. Speaker?
Microwave Prime Minister.
If the member for Diego Martin North, he says that if the Prime Minister serves for 5 seconds, 5 hours, 5 days, he wants to give him all of the pension, Mr. Speaker. All. And we are saying absolutely no to that, Mr. Speaker. We are saying no to that. We are saying absolutely no to that. How could that be fair? How could that be fair? They wanted to offer the public servants 4%, and that is why they have been voted out of office, Mr. Speaker. You see, and the minister cherry-picked from jurisdictions. But let's go back to England, where we derive some of our laws from. Cherry-picking, Mr. Speaker. This is from the UK Parliament House of Commons Library website, Mr. Speaker. And this says that there is a parliamentary contributory fund scheme, Mr. Speaker, pension fund, and it's statutory in nature. And before, in England, the Prime Minister used to get a Prime Minister's pension. They decided, Mr. Speaker, England, to say this. In the past, and I'm quoting the article, in the past, there were separate arrangements for the pensions for the 3 great officers of state, the Prime Minister, Speaker of the House of Commons, and Lord Chancellor. These gave entitlement to a pension of half the final office holder's salary on leaving office, regardless of length of service. Payments were met through the Consolidated Fund. However, the Public Service Pensions Act 2013 abolished these arrangements for future office holders who would instead be covered by the Ministerial Pension Scheme. The pensions of existing office holders continued to be met from the Consolidated Fund, even when they signed a waiver for their full entitlement under the old arrangement. What does that mean, Mr. Speaker? Even in England, they reformed their system with respect to Prime Minister's pension. So who is Trinidad and Tobago? We can do it. So the Prime Minister in England now falls under the same ministerial scheme as the members of the Cabinet. What's wrong with that? What is wrong with that? Again, the Minister saw the Bahamas, Mr. Speaker, and I just want to focus on Bahamas. In Bahamas, if the office holder serves according to Section 3 of their Act, it means, Mr. Speaker, they will get, if it's less than 4 years, they will get half of the pension. If they serve at least 8 years, they'll be given the full pension, prorated. This is the same thing that we're doing, just a different formula, Mr. Speaker. Barbados, same thing. In Barbados, the pension is calculated at 2/3 of the highest annual rate of salary of such person. So there's no jurisdiction, each jurisdiction varies. And if we decide to vary in Trinidad and Tobago, nothing should be wrong with that. And Mr. Speaker, what we are saying is that we must be fair across the board.
Of course.
We have to be fair. In the public service, there are several offices that are pensionable, and I want to focus on us right here.
That's right.
Members of Parliament, members of the Cabinet. But, Mr. Speaker, in terms of senators, they are not considered to be legislators and are not entitled to a pension because they don't have portfolio. So while they pass laws and make laws, they are not considered to be legislators. Wow. Mr. Speaker, according to the Retiring Allowance Legislative Service Act, Chapter 203, in order for a minister or a member of Parliament to be given a pension or entitled to a pension, he must serve as a legislator for a period for periods amounting in aggregate to not less than 5 years. So your first qualification, you must serve here for at least 5 years. Second, you must cease to become a legislator. And third, you have to attain the age of 55. But if you have not attained the age of 55, if you can justify it on grounds of illness or sickness, you will be entitled to the pension. So, it then goes on, Mr. Speaker, When you look at the entitlement to the office holder, it's not that they're going to get the same salary they left at. It's also prorated for the members of parliament and the cabinet members. If they serve not less than 5 years, they get 1/6 of the 1 year salary of that, and the minimum being $3,500. In the case of a person who served as a legislator for 2 consecutive full parliamentary terms over a period of not less than 9 years, for the period, he will, or not less than 10 years, he will be given an annual rate equal to 1/3 of the annual salary. If the person served, Mr. Speaker, 3 full parliamentary terms extending over a period of not less than 13.5 years, or for periods not amounting in aggregate to less than 15 years, be at an annual rate equal to 1/2 of the 1 year salary. And if the person has served 4 full parliamentary terms extending over a period of not less than 18 years, or for periods amounting in aggregate to not less than 20 years, be at an annual rate equal to 2/3 of 1 year of the salary. So, Mr. Speaker, even the Retiring Allowances Act has a prorated formula. So what we are doing, Mr. Speaker, is nothing new. This is already in our law. But we're speaking of the elected officers. What about the ordinary public servants? What about them? What about the ordinary public servants, Mr. Speaker, who is not entitled to $87,000 per month? What about them? According to Section 4 of the Law Reform Pensions Act, Chapter 23, 59, a person who holds office in a pensionable office other than in the Defence Force, who completes 5 years unbroken service and is confirmed in the office, it will be 10 years according to Section 9.2 of unbroken service, is now being entitled to a pension.
10 years.
Right? They have to serve at least 10 years in the public service, right? And then there's the maximum of the 33 1/3, where it will be capped off to 2/3 of the pension, right, Mr. Speaker? And that can be found at Section 9.2 of the Act. But, Mr. Speaker, this is important. The Pensions Act, Chapter 2352, says, when you read it, that there is no absolute right to a pension or gratuity. There's no absolute right. In fact, the right to life is not an absolute right.
You say that from Farah.
So I don't know if the Senator Al-Rawi told them about Surat and Suraj, but, Mr. Speaker, there's no absolute right. In the Constitution, rights are qualified. They're qualified rights. Because the state, according to Section 9.1 of the Pensions Act, can dismiss a person with 0 pension or a reduced pension or gratuity if the officer has been found guilty of negligence or misconduct. So, if the public servants are being treated in this manner, why should the Prime Minister be treated so special, that office? We understand the importance of the office, but we must be fair, we must be proportional, and we must be reasonable. Mr. Speaker, and their salary is calculated at really 1/600 of the completed period after the 10 year, and then you have the 2/3, Mr. Speaker. And the 33 years. And, Mr. Speaker, I want to put this in context so that members of the public who are listening can understand what I'm saying. So I ask for the public service to provide me with what is the pension of an officer who served the full 33 1/3, not the 10 years, the 33 1/3. Messenger 1, range 9, the salary is about $5,600. After 30 years service, Mr. Speaker, their pension would have been $2,826, but it's now capped to $3,500. A Clerk 1, range 14, $6,266. Again, their cap would be $3,500. A Clerk 3, range 24E, about $8,000, after 33 1/3 service, will receive a pension of around $5,300, $5,400. Human Resource Officer 1, range 46, salary of about $11,800. After 33 1/3, will get about $7,800. Director of Human Resource, $18,351. After 33 years of service, about $12,000. And then the member for Diego Martin Northeast wants to say a 5-second Prime Minister should be entitled to $87,000 per month. We are saying no to that, Mr. Speaker. We are saying absolutely no to that. Mr. Speaker, but you see, the member for Diego Martin Northeast is often wrong. he is often wrong, Mr. Speaker, because he started, and I would advise the member for Diego Martin Northeast to stay away from court case something. Because he quotes the wrong thing, he reads the wrong thing, and then he misleads the House using the wrong thing. Mr. Speaker, look, I have the case here in my hand, right, Mr. Speaker? This is the same case he's talking about with respect to the member, sorry, the honourable member, of the Privy Council Appeal 14, 15, 16 of 2015, Steve Ferguson against the Attorney General and others. And Lord Sumption would have given the decision in that matter, Mr. Speaker. And remember, I think I had to ask the member for Caroni Central next to me. He said that the legislation was struck down. Mr. Speaker, that is wrong. The Privy Council upheld the constitutionality of the repeal bill. They upheld the constitutionality of the repeal bill. And the appellants in the matter raised an issue of ad hominem. And at paragraph 31 of the decision, it says it follows that the challenge to the amending act on this ground can succeed only if it's shown that the terms, although framed generally, would in practice apply only to a limited category of people, including the appellants against whom it can be said to have targeted. But this is manifestly not the case. What did the member read? The Privy Council is saying that is not the case. The legislation was not ad hominem. The appeal was in fact the appeal was in fact dismissed, Mr. Speaker. The appeal was in fact dismissed. So the member should not be telling this honourable House about court case because he may end up before the Privileges Committee again. He may be referred. I take that back, Mr. Speaker. He may be referred to the Privileges Committee again. He was not referred. He did not attend.
He says he no longer getting caffeine.
Mr. Speaker, I know you're probably not getting the coffee. Yeah, the coffee that he wants. But Mr. Speaker, what the bill before the House is doing, Mr. Speaker, as I said, correcting a historical wrong. The bill is proportional. The bill is reasonable, and the bill is lawful, Mr. Speaker. It is lawful. And Mr. Speaker, I want to end my contribution with these few words that I have sight to see before I came into this chamber, where the member for Port of Spain North, St. Anne's West put on Facebook, and I quote, "I did not enter politics for personal material benefit." Mr. Speaker, this is a man who recused himself over 137 times from the cabinet.
Let's not walk on the road of irrelevance.
So, Mr. Speaker, what we are doing, we are protecting the public's interests, and I commend every single member of this Parliament to do the right thing and vote in favour of this particular bill, Mr. Speaker, and I thank you very much.
Mr. Speaker, I commence with the analysis of the retroactive nature of the parent bill mentioned by the Honourable Member for Barataria Sanwan, and say that that is a misplaced, misguided, and highly fallacious interpretation and representation as to what happened in 1969 with the parent bill and its retroactive nature. The 1969 parent bill, which had a retroactive effect, conferred a benefit on past prime ministers who performed the functions of prime ministers between 1962 and 1969. It did not take away a benefit. This legislation, at its core of Section 3, purports to take away a benefit. And it is strike law, Mr. Speaker, that you can retroactively confer a benefit, but you cannot retroactively take away a benefit. That is a distinction. Mr. Speaker, as it relates to reform on this side, There is no objection to reform, but it must be done constitutionally correct, and it must not be ad hominem and in contravention of every possible constitutional legal principle that one can imagine. The Prime Minister's Pension Amendment Bill 2025 seeks to amend the Prime Minister's Pension Act, Chapter 251, which governs the payment of pensions to persons who have served as Prime Minister and other related matters, including source and method of payment. The bill introduces two significant amendments: the introduction of a minimum service requirement, and according to Section 3 of this Act, a person appointed as Prime Minister on or after the 31st of August 1962 automatically qualifies for a pension regardless of length of service. Clause 5 of the bill seeks to amend the section of the Act, Section 3, by introducing a requirement that a person must serve as Prime Minister for at least 1 year from the date of appointment in order to be eligible to receive that benefit. The second aspect of this bill, Mr. Speaker, is the introduction of a tiered system, and Section 4 of the bill states that the Prime Minister is entitled to receive a full amount of the highest annual rate of salary they were paid at the time while serving in that role. That is the Act. Section 6 or Clause 6 of this bill repeals the automatic full entitlement, replacing it with a system where the pension will be calculated based on the length of service and according to the following tiered structure. Not less than 1 year of service, the person is entitled to 1/3 of the highest annual salary payable. Not less than 2 years service, the person is entitled to 1/2 of the highest annual salary. Not less than 3 years service, entitled to 2/3 of the highest annual salary, and not less than 4 years entitled to the full amount of the highest annual salary. Clause 2 of the bill states pellucidly that this bill shall come into force on the 10th day of March 2025, thereby giving it its retroactive vires. Clause 3 of the bill expressly states that it shall take effect even though it is inconsistent with Sections 4 and 5 of the Constitution. And I pause here, Mr. Speaker. Sections 4 and 5 of the Constitution protects enshrined fundamental rights and freedoms of all citizens of Trinidad and Tobago. What is happening here is that there is an attempt to interfere with the fundamental rights and freedoms of a citizen of Trinidad and Tobago. Pursuant to Section 13 of the Constitution, Mr. Speaker, this bill must secure a 3/5 special majority in both the House of Representatives and the Senate to be enacted into law. Once that special majority is achieved, Mr. Speaker, the bill can have, under those sections, its full powers. But it is crucial at this point, Mr. Speaker, to lay down a marker as we try to uphold enshrined constitutional rights which serve as the bedrock of our democratic framework. These rights were not placed in the Constitution to be wielded capriciously or ad hominem, nor should they be subject to attack, be it political attack against your perceived enemy or attack of any individual who the government of the day wishes to target. As it relates to the prospective future thinking of the bill. It seems, Mr. Speaker, that a tiered pension structure is the order, the practice in Commonwealth and other jurisdictions seems to be going in that direction. Future thinking. So, for example, in the United Kingdom, former prime ministers receive a pension via the Public Duties Cost Allowance Act, which is discretionary and partially dependent on length of service. In Canada, a prime minister's pension is based on the number of years served both as MP and as a cabinet minister. In Australia, after the 2004 reforms, former prime ministers' pension are tied and pegged to their superannuation and public service tenure. In New Zealand, former prime ministers receive pensions on a graduated scale depending on years served, and members of Parliament Remuneration Services Act. And in India, former prime ministers receive pensions as former members of Parliament under the Salary Allowance and Pensions of Members of Parliament Act. I adopt whole scale the position from the Honourable Member for Diego Martin Northeast as it relates to Jamaica, Barbados, and say that they are in pari materia. They are the same as exist now in Trinidad and Tobago. So, it seems that this is the way the world is going as it relates to prime ministers. And there's a rationale behind it. The reverence and the holding of such persons as prime ministers and office holders, that mystification is being removed, and they're going more to a democratization of it, and we understand that. Our problem is the way that this is being done, and it is founded, Mr. Speaker, the jurisprudential objection, the jurisprudential disquiet that is apparent from this piece of legislation comes, Mr. Speaker, from Jonathan Sumpton, formerly known as Lord Sumpton, in his new book, Challenges of Democracy. And under the rubric Rule of Law, this is what Lord Sumpton had to say. Mr. Speaker, I thank you for your intervention, but we do differ in our pronunciation. So I will stay with mine, and you will stay with yours. Respectfully, Mr. Speaker. As I have previously observed, the first requirement of the rule of law is that the law should be such that people can be guided by it. In other words, it must be stable, publicly accessible, clear, and not retrospective. Mr. Speaker, these are the words of one of the most, to me after Lord Bingham, one of the most revered law lords who have graced the halls of both the House of Lords and the Privy Council. And for those, I am mystified by the submissions and the articulation of the Honourable Member for Barataria Sanwan. I do not understand it up to now. And then, no one here, Mr. Speaker, has addressed the issue. We are early in the debate still. But what about Section 13 of the Constitution and the concept of reasonably justifiable? Mr. Speaker, Section 13 of the Constitution is very clear, and this is what it has to say. Section 13(1). An act to which this section applies may expressly declare that it shall have effect even though inconsistent with sections 4 and 5. And if any such act does so declare, it shall have effect accordingly unless the act is shown not to be reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual. Mr. Speaker, I know that you, the chair, is acutely aware of the decision of Justice of Appeal Barrow in Francis Hines and the state, and particularly his distilling of the principles that apply and how Section 13 works. So let's examine this in the context of what we are doing here today. We will hear ad nauseum that the government has numerically their 3/5 majority. We understand that. And we understand that the recital in the bill says that it is inconsistent with the Constitution. But the issue that has to be determined, that even in spite of a 3/5 majority, is this reasonably justifiable in a society that has proper respect for the right and freedom of the individual? If this legislation is, after the peeling away of all the attempts at semantics, if it is geared towards an individual, a group of persons, is this government saying that we are prepared to use our special 3/5 majority to take away rights of persons who we consider our political enemy? Today, it may be an old person. Tomorrow, it may be someone named Hilaire. Day after, it may be anyone. But this is where the marker must stop. Because, Mr. Speaker, if you peel away again the facts from independence, and I took my time to do the research so that I can do the math, Mr. Speaker, and then come to my conclusion as to who possibly could the retroactive nature of this act going from the 10th of March 2025, which possible prime minister could this piece of legislation affect? So, Mr. Speaker, let me deal with context now. Dr. Eric Eustace Williams served as prime minister from the 31st of August 1962 to the 29th of March 1981. 18 years, 6 months, 27 days, 4 terms. This act does not apply to him. Mr. George Chambers served as prime minister from the 30th of March 1981 to the 18th of December 1986. 5 years, 8 months, 18 days. This act does not apply to George Chambers. Mr. Arthur Napoleon Raymond Robinson served as prime minister the 19th of December 1986 to the 16th of December 1991. 4 years, 11 months, 27 days. This act does not apply to Arthur Napoleon Raymond Robinson. Mr. Patrick Manning served in his first incarnation as Prime Minister of Trinidad and Tobago from the 17th of December 1991 to the 8th of November 1995. 3 years, 10 months, 22 days. This act does not apply to him. Mr. Bodoe Pandey served as Prime Minister from the 9th of November 1995 to the 23rd of December 2001. 6 years, 1 month, 14 days, 2 terms. Mr. Patrick Manning served again as Prime Minister from the 24th of December 2001 to the 25th of May 2010. 8 years, 5 months, 1 day. Mrs. Kamla Prasad Bissessa, Senior Counsel, served as Prime Minister in her first incarnation from the 26th of May 2010 to the 8th of September 2015. 5 years, 3 months, 13 days, 1 term. Dr. Keith Rowley served as Prime Minister from the 9th of September 2015 to the 16th of March 2025. 9 years, 6 months, 7 days. Stuart Young, Senior Counsel, served as Prime Minister from the 17th of March 2025 to the 30th of April 2025. 1 month and 13 days. Mr. Speaker, the math. And let me just be complete. Honorable Prime Minister, Mrs. Kamala Prasad-Bissessar, Senior Counsel, is serving as Prime Minister from the first day of May 2025 to present. Mr. Speaker, what does the math, when you do the equal sign, what does the math say from this legislation that is backdated or that is earmarked to be retroactive from the 10th of March 2025? If this is not ad hominem legislation, I don't know what could qualify as that. Mr. Speaker, on another note, it has been alluded to, and the Honourable Member for Diego Martin Northeast touched on it, but I would like to drill one layer further. There's been a mention of an argument en passant that the appointment made in this country earlier this year may have gone against, may have been unconstitutional. Mr. Speaker, to date, we have not had one challenge to that. And Mr. Speaker, you will readily appreciate the presumption of regularity until such time as anyone from the other side decides to stop talking that kind of unsubstantiated commentary and then put their money where their mouth is and challenge it in the court. That is the position. So until such time, Section 3 of the Act kicks in and the ad hominem aspect of this bill attaches itself to the person and the only one person who this is targeted against. And Mr. Speaker, I have this to say. The courts around the world have held that laws that are ad hominem are deemed to be unconstitutional, ultra vires, and void for violating not just the rule of law, but sometimes also the separation of powers. And here is where I part ways again with the Honourable Member for Barataria San Juan. The Honourable Member for Barataria San Juan misquoted the submission made by the member for Diego Martin Northeast in the Galba-Ransing case. And, Mr. Speaker, in this case, for avoidance of any doubt whatsoever, Privy Council Appeals number 0014 to 0016 of 2015 when Section 34 was repealed, the appellants, Ferguson and others, challenged the repeal, saying, we have already filed our claim to have our motion, to have our matters dismissed pursuant to this repeal section. In repealing this section, you are targeting us. The Privy Council says, no, because they were saying, because it is, in their view, affecting them, it was ad hominem. The Privy Council said no. The Privy Council said every person who has a case 10 years and over that's at a PI stage is covered and is caught by this repeal, not just you. I asked a rhetorical question to Trinidad and Tobago through you, Mr. Speaker. Who alone is caught by the retroactive nature of this piece of legislation? The speakers who are to come after me, name the individuals, the group of persons, the class who are affected by this attempt of retroactive legislation that is being hoisted upon Trinidad and Tobago. And it has nothing to do with the amount of salary or anything being received by anyone who held the office before. It has everything to do with the principle of the rule of law. And on this side, if there's good legislation, we support it. If there's legislation that can pass the test, not ad hominem, but reasonably justifiable in a society that respects the rights of an individual, we support it. And this, Mr. Speaker, I want to now go to my last aspect, which is the distilling, as I promised, of Section 13 by Justice of Appeal Barrow. In the case of, and because I'm reading it on the record, Francis and Hines versus the state. And this is what Justice of Appeal Barrow had to say whilst distilling Section 13(1) of the Constitution. Section 13(1) of the Constitution, in many respects, recognizes all that democracy encompasses in a society which rights compete and collide. While there is a necessity for the minority to accept the majority view, and there is a necessity for all rights to submit to the public interest, there is also an acceptance that the view of the majority is not necessarily right. It was Thomas Jefferson on the 4th of March, 1801, in his first inaugural address as President of the United States, who noted that though the will of the majority is in all cases to prevail, that will to be rightful must be reasonable. History is littered with examples in which the majority view initially prevailed, but it was ultimately not just unreasonable, but wrong. Here are the examples: slavery, segregation, the Holocaust comes to mind. I will add indentureship. The inclusion of the proviso in Section 13(1) of the Constitution is a recognition of the fact that the majority view may not necessarily be the right view. Let me repeat it, because there's a 3/5 majority. The inclusion of the proviso in Section 13(1) of the Constitution is a recognition of the fact that the majority view may not necessarily be the right view. It reposes in the judiciary the heavy responsibility of declaring legislation undemocratic, despite the views of the majority of those elected to represent the people. In coming to any decision under Section 13 of the Constitution, therefore, due deference must be paid to the intention of Parliament. But ultimately, the responsibility is one from which the courts cannot shirk. Legislation which is undemocratic for the purposes of Section 13(1) does not become any less so by the imprimatur of a parliamentary majority, 3/5 or otherwise. So, beat your chest. For now, the time for self-aggrandizement will soon come to an end, honorable members on the other side. Mr. Speaker, in closing, I wish to say that there is no and there can be no objection as it relates to reform. There can be no objection as it relates to having the right approach to cure a lacuna that exists in the system. And if the right approach is taken, it will be supported by this side. Mr. Speaker, may I just have one moment to confer with the whip, please? Thank you. Mr. Speaker, today, Today, I will not be distracted.
48-1,
Yes,
Mr. Speaker.
yes,
48-1. This is not relevant to...
I think the member is winding up. Let's allow him. I suppose you've taken your seat, so
No,
you're
Mr.
finished.
Speaker. Mr. Speaker, I am not finished. They were speaking, and I was waiting for them to stop.
All right,
Thank you, Mr.
let's end the
Speaker.
argument. I'm going
about-
to give you some leeway, but you took your seat when no one else was standing, but finish your contribution.
Thank you, Mr. Speaker. I'm indeed obliged. So, Mr. Speaker,
Mr. Speaker, 48-1. Did he abandon the relevance? And I'm asking, did he abandon his speaking time and just moved away?
I told the member that he moved, but I will give him his time. Come on,
Thank you,
finish
Mr.
off.
Speaker. Mr. Speaker,
Stick to your promise, Port-au-Prince South,
Mr.
and let's
Speaker,
move along to finish.
we are saying that the particular mischief of meritocracy can be cured if this goes to a joint select committee of this Parliament to properly distill the issues that are meant to be addressed by this ill-fated piece of legislation. Mr. Speaker, I thank you.
Member for Rockwell St. Joseph.
Mr. Speaker, a point of order before the member for St. Jude. I want to raise a standing order for clarification. Mr. Speaker, I want to turn your attention to 53, rules for members, 52 rather than 53. Mr. Speaker, we had a moment ago something that is a bit unprecedented, where a member has abandoned his seat in terms of his speaking position and moved up to confer, and we didn't know what was happening there. And I think that is an utter disrespect and contempt for the chair and the Speaker of the House of Representatives. And therefore, I would like a ruling, Mr. Speaker, in terms of that atrocity that we just saw happen in terms of the disrespect to the chair.
Whilst I recognize that there's a certain decorum, order of business in the conduct of the business of the House, a certain manner in which the business of the House must be conducted, I wish to say that I do not take offense easily. That is not to invite members to flout the rules. I wish to say that I'm not overly fastidious about the observance of these rules to the letter, but I'm not inviting an open revolt. I wish to make that clear. I understand what the member did. I think it is, perhaps it might be extraordinary, perhaps it might be unprecedented. It is not to be encouraged, but I'm not going to censure the member for that. Have a seat. I'm not going to censure the member to that. I'm not going to accede to the invitation to pronounce on the rightness, for want of a better term, or the wrongness of it. All I'm going to say, and Member for St. Augustine, allow me to continue in some silence, please. You don't have to contribute to it, Port-au-Prince South. I'm fully capable of dealing with this on my own. Please, thank you. So I'm not going to say that my unwillingness to issue a censure at this stage ought to be reflective of an unwillingness to do so in the future. I fully understand what you were doing. I saw the dynamic at play unfolding within the chamber. I would discourage that kind of behavior. What I find perhaps even, I just simply want to use very neutral language. This is a simple 6-clause bill. can we just please, for the sake of getting on with the people's business, stick to the matters at hand? And if we could resist the temptation of engaging the invocation of the standing orders in circumstances where they are plainly unjustified in doing so. The behavior has been relatively good this evening. So if we could continue along that stage, and I see the Chief Whip eagerly with his standing orders in hand, and I suppose he's very well, I'm assured. So can I call on the member for Arangwe St. Joseph now?
Thank you very much, Mr. Speaker, for the opportunity to contribute on this most important bill. This bill, Mr. Speaker, seeks to bring greater clarity, fairness, and accountability to the framework governing pension entitlement for individuals in the position of Prime Minister. Mr. Speaker, the bill before you, it's a very short bill containing 6 clauses, but it's a bill that ensures that this government protects the public purse. We on this side have been chosen by the people of Trinidad and Tobago to scrupulously guard every aspect of public spending, and this bill is one such measure that improves the framework how pension payments are to be made to prime ministers in Trinidad and Tobago. Mr. Speaker, the amendments before this Honorable House are grounded in the principle that pension benefits for holders of high constitutional office must bear a transparent and reasonable correlation to the length and substance of public service. Under the current framework, the law allows for the payment of a full pension to every person who has served as Prime Minister, regardless of the duration of that tenure. What is now proposed, Mr. Speaker, is a more measured and proportionate approach, ensuring that pension entitlement is commensurate with actual time spent in that distinguished office. Now, Mr. Speaker, we have heard many arguments, but basically on 2 fronts from my learned friends on the other side, one of which is the ad hominem point, and the other retrospectivity or retroactivity, as it is called in certain quarters. Mr. Speaker, the question of ad hominem is easy to be dispensed with, and in short order. The argument is structured that a law must be applied generally and not to specific persons or group of persons. Mr. Speaker, by its very nature, the law has to be addressed to a specific person or a specific office. By its very nature, the act before the House that is to be amended, Mr. Speaker, is called the Prime Minister, the original act, Mr. Speaker, it's the Prime Minister Pension Act. So any amendment to that act will have to affect a Prime Minister or Prime Ministers. How are you going to get around that argument to say that the law should be general, and if it is specific to a Prime Minister, it is ad hominem, but it deals with Prime Ministers. So it deals with a particular category of persons, which are Prime Ministers. where's the ad hominem argument? It just doesn't fly. We can't use the Prime Minister's Pension Act to amend something with the Speaker or with members of Parliament. It has to deal with Prime Ministers. So one has to understand the principle of ad hominem. You have to separate that argument. In the case of Ferguson, when it was taken before the Privy Council, a group of persons said that you were targeting us. So therefore it was ad hominem. And the law lords ruled that no, it wasn't just targeting you. It was everybody who was over 10 years who was charged. So therefore that argument failed. You're taking that principle and trying to apply it to a piece of legislation which deals specifically with one office and not a general group of persons. That argument must fall flat, and soon it is uttered, must be dispensed with. The second point, Mr. Speaker, of retroactivity or retrospectivity, my lord. The law is clear. It has been repeated many times by judges in this jurisdiction, but as my learned friend from Diego Martin Ortiz raised the case of Ferguson, my lord, as he raised it, I would also quote from the case. So the principle being generally that you must not have retrospective legislation which disturbs vested rights. They're saying there's a vested right in the Prime Minister's pension and it ought not to be disturbed. That is, I understand the argument. What does the law lord say? In paragraph 24 of that same judgment, my lord, this is what Lord Sumption had to say. I see my learned friend here has departed from the chamber. Lord Sumption, my lord, I hope my pronunciation is meeting your
I can say this by way of explanation. In every Privy Council case I've looked at, I've always heard it pronounced assumption. But people have different preferences.
I take guidance with me, my lord. I will have a word with my friend outside of this chamber. This is what Lord Sumption had to say, my lord. Once it is established as a matter of construction, mere retrospectivity does not violate the separation of powers. So I'll pause here. This has nothing to do with separation of powers. I heard my friend touting that phrase, separation of powers. The separation of powers is well known. The executive, the legislature, judiciary. This section does not even come and bring any of those elements into question. There's no question of separation of powers. So let's move on. Or the rule of law and is not contrary to due process. Rule of law and contrary to due process. We are following the rule of law. We are saying if it is a vested interest and it is disturbing that vested interest, we are coming under section 13 of the Constitution. What does section 13 of the Constitution tell us, Mr. Speaker? There's something that you have been very familiar with, and I will just draw it to your attention and for the general listening audience. And section 13 says, an act to which this section applies may expressly declare that it shall have effect, even though inconsistent with sections 4 and 5. And if any act does so declare, and this amendment act does so declare, and for purposes of clarity, I will just just read, my lord, the preamble to the act. It does so declare. Where it is enacted by section 13(1) of the Constitution, that an act of Parliament to which this section applies may expressly declare that it shall have effect, even though inconsistent with Section 4 and 5 of the Constitution, and if any act does so declare, it shall have effect accordingly. So I'll continue reading, my lord. And if any act...
Mr. Speaker.
Mr. Speaker, sorry, I do apologize. And if any act does so declare, it shall have effect accordingly unless the act is shown not to be reasonably justifiable in a society that has proper respect for the rights and freedoms of individuals. Any vested right, once it is passed in accordance with the Constitution, can be effective. I'm sure my learned friend from Port of Spain South knows that. So he kind of dallied around the subject, so to speak. Does this amendment, my lord, Mr. Speaker, does this amendment, is it reasonably justifiable in a society that have proper respect for rights and freedoms? And that is the question that we must come to grips with. When one looks at the situation, my lord, Mr. Speaker, I really have to go back to where I was.
You don't have to go there.
Mr. Speaker, the point being, my lord, in terms of a historical perspective, Mr. Speaker, the The 120th report of the Salaries Review Commission, established under 140 of the Constitution of the Republic of Trinidad and Tobago, in accordance with 141(1) of the Constitution, that commission was mandated to periodically review, with the President's approval, salaries and other terms and conditions of service for officers under its purview. Mr. Speaker, once such a review was finalized, that report is submitted to the President and subsequently forwarded to the Prime Minister for Cabinet's consideration before being laid in both houses of Parliament. Mr. Speaker, the 120th report of the SRC, dated October 24, 2024, was laid in Parliament on November 15, 2024. That report, Mr. Speaker, proposed revised salary structures for several high office holders, including the President of the Republic, the Prime Minister, the Opposition Leader, the Chief Justice, the Chief Secretary of Tobago House of Assembly, government ministers, and members of Parliament. Mr. Speaker, on the other side, members of this side urging against it took steps to ensure that the report be adopted and the Prime Minister's salary was adjusted from $80,000 for the period October 1st, 2020 to September 30th, 2023, with an adjustment to $87,847 effective from October 1st, 2023. Mr. Speaker, it was the other side that chose to accept and implement this drastic 47% increase in salary from $59,000 plus to $87,000 plus, knowing full well the gloomy economic situation facing our country. The effect of this escalated salary directly impacted the amount of pension payable. We are here today, Mr. Speaker, indirectly, to tame this wild horse and introduce some proportionality in the pension benefits payable to Prime Minister. The reason I raise that, Mr. Speaker, is that we have to justify to the public that this amendment is reasonably justifiable. How can we sell to the general public of Trinidad and Tobago that a Prime Minister who served less than a year is entitled to a full pension of $87,000 for the rest of his life? No, I am saying according to this amendment. We are telling the population that a highest office holder, you serve less than a year and you're entitled to $87,000. But the man on the street, his pension is not even settled, Mr. Speaker. I will give you some points about that pension, Mr. Speaker. Workers in a public service have to achieve 33 1/3 years of service to get a full pension. 33 1/3 years. We are telling the public that a prime minister who served less than a year should get $87,000. Is that reasonably justifiable in a society that have respect for rights and freedoms of individuals? It's a rhetorical question. Additionally, persons who are members of private pension funds have to contribute 5 years before a reduced pension can be paid, and it is calculated on the years of service in relation to the accumulated years of same. So public, 33 1/2 years. Public, 5 years when you get a reduced pension. Up till today, Mr. Speaker, the pension plans of a number of companies which the other side closed down have not been fully addressed. For example, Caroni Limited and Petrotrin are two classic examples. So the general populace is being treated to a different medicine. Private persons are treated to a different medicines, but yet when it comes to the Prime Minister, the position of Prime Minister, you are telling this country, and if you spent less than a year in that office, you're entitled to walk away with $87,000 a month. Is that reasonably justifiable? And for the rest of your life. For the rest of your life. And you want to come here and argue retrospectivity and try to tell the population that we cannot pass retrospective legislation to deal with what my learned friend from Port of Spain said, a lacuna. It is indeed a lacuna. Progressive societies of the world have addressed this situation. Right in the Caribbean, Antigua, I think Minister of Finance, Antigua and Barbados have similar tiered systems. So we are introducing and we are bringing progressive amendments to our legislation. And you are telling us that we can't address it retrospectively. I am telling you, go back to the Privy Council judgment, read what Lord Sumption have said, read what our local court of appeal have said, and they are telling you, yes, you can do it once it is reasonably justifiable. And I'm saying, and I'm making this submission to the House today, Mr. Speaker, that it is reasonably justifiable. I don't want to have to go through all the amendments that have been gone through by my learned colleagues from Oropouche, East, West, and Sour. The clause 5, Mr. Speaker, which amends section 3 of the Act, introduced a minimum service requirement. It provides that an individual must serve in the capacity of Prime Minister for less than a year to qualify for the pension. And that was a significant departure from the current position, which allows for an automatic qualification regardless of duration of service. And you know, Mr. Speaker, the issue, we must listen to the population. The issue in recent months ignited a justifiable wave of public concern and national debate. Citizens, union representatives, political voices across the spectrum have raised alarm of what is widely regarded as a disproportionate and poorly regulated benefit scheme. As Honorable Prime Minister reminded this nation, even as us parliamentarians must serve a full term and attain an age of 55 in order to receive a pension. Members of the public must reach 60, and senior citizens must attain 65. Yet no minimum standards have been applied to the office of Prime Minister, one of the highest and most consequential in our country. That has to be wrong. That has to be wrong, Mr. Speaker. We are trying to bring equity and fairness back to this House, back to this position, back to the issue of pension benefits, because we are saying if it applies to one in this country, it must apply across the spectrum to all. And what is unreasonable, what is offered, Mr. Speaker? What is unreasonable? 1 year of service entitles a former Prime Minister to 1/3 of the highest annual salary paid. 2 years, 1/2. 3 years, 2/3. And 4 or more years, the highest amount of the highest salary received. Fairness, equity across the board. The poor man on the street hasn't got, carony workers and petrol trade have not got their pension regularized. You did not regularize it, yet you want to walk away here $87,000. This can't be correct. The tiered system, Mr. Speaker, is both rational and equitable. It ensures that pension benefits are aligned with actual service and provides a fair mechanism to calculate entitlements. It is important to also underscore that the provisions contained in this proposed bill reflect a more proportionate and equitable approach which is consistent with the principles I've already indicated of fairness, accountability, and responsible governance, and responds to legitimate public expectations regarding the prudent and just use of state resources. This amendment comes at a time of heightened public discourse surrounding pension eligibility, particularly in cases where period of service in high office has been exceptionally brief. While the existing legislation may technically permit such entitlements, it has revealed a lacuna which calls into question the principle of proportionality. And Mr. Speaker, the media houses, everybody have been raising noise about this. We have been voted into government on the basis of listening to the voices of the national public. And just as we have done with our Children's Life Fund, just as we have done with the repeal of the TTRA, we have come today to cure a mischief, a lacuna in this legislation, so that the people of Trinidad and Tobago ultimately may benefit, Mr. Speaker. We are saying, Mr. Speaker, in any well-governed and principled democracy, pension benefits for holders of high office should be grounded in substance of service, the responsibilities undertaken, the duration of tenure, and the demands of the role, and not merely from the fact of appointment. We have moved away from that. The current framework does not differentiate between sustained leadership and temporary occupancy, including those arising out of transitional or exceptional circumstances. Mr. Speaker, the people of Trinidad and Tobago understand sacrifice. Many of our citizens work their entire lives, whether in public service or private sector or self-employment, and retire with modest pension benefits. In light of this reality, it is reasonable to question whether substantially greater entitlement should accrue to those who serve for a very limited time in high office. while all public service is to be respected, the level of benefits must be commensurate with the contribution made, regardless of what position that you have. The amendments proposed by this bill strike a careful and necessary balance. They ensure that our pension entitlements are reflective of meaningful, sustained service rather than short-term occupancy. This is not only a matter of sound financial management, but it is one of public confidence and ethical governance. Mr. Speaker, this is a measured and national reform, one that safeguards the dignity of the office of the Prime Minister whilst reinforcing the trust of the citizenry in the laws that govern us. Mr. Speaker, I commend this bill to the House and look forward to the contribution of my other colleagues.
Member for Arima.
Thank you very much. Thank you very much, Mr. Speaker. And Mr. Speaker, I rise to join this debate on an act to amend the Prime Minister's Pension Act, Chapter 251. And Mr. Speaker, as I rise to join this debate, I want to suggest that this demands our highest standard of judgment. The reform of the pensions for former prime ministers. And this issue goes really to the heart of public trust, fiscal responsibility, and the dignity of our highest office. Mr. Speaker, I have listened to many, and I'm referring specifically to the last speaker that talked about the issue of equity and fairness, listening to the population, and I want to make it abundantly clear that when one examines the legislation from a multiplicity of countries, European countries, African countries, CARICOM region, we have seen that the issue of pension reform as it relates to prime ministers and members of parliament, that has been occupying parliaments now, particularly over the last couple of years. And more so because some prime ministers are becoming younger, and with the challenges, economic challenges in a multiplicity of countries, the issue of pension for prime ministers and parliamentarians is one that has been occupying a number of parliaments. As a matter of fact, Mr. Speaker, if we were to read the newspapers in Barbados at this very time, we would see that debate as it relates to pensions for members of parliament, the Prime Minister and others, is taking place at the same time that we are doing our debate here in Trinidad and Tobago. Mr. Speaker, I want to share with you a very interesting situation that occurred a couple of years ago in the CARICOM region that resulted in the intervention of CARICOM to address a matter where a prime minister at that time, having lost elections, was denied his pension by the incoming government. Mr. Speaker, I make reference to the fact that at the time, the Right Honorable Sir Kennedy Simmons, who I'm sure you're familiar with, he was forced to wait a period of more than 2 years because the new government decided that they were not going to give him his pension. And, Mr. Speaker, it resulted in CARICOM having to intervene to ensure that the Prime Minister, the former Prime Minister, got his pension. And what happened is that he was the Federation's first Prime Minister, and he served a period of 12 years, that is to say from 1983 to 1995. And he indicated that by denying him his pension, it was a blatant act of malice and victimization by the then Prime Minister, Dr. Douglas. If you could just allow me to read a paragraph which said the press release of Dr. Simmons was brought to light by the Prime Minister of Finance at the time, Dr. Timothy Harris, in the wake of a legal claim made by then Senator Richard Skerritt against the Prime Minister and the Attorney General for withholding payments of his outstanding gratuity and pension, although they say he had not answered a letter sent to him asking him to clear up the perceived irregularities in relation to subsistence before such monies can be settled. Now, Mr. Speaker, what later happened is that Dr. Simmons indicated that the later Prime Minister, Dr. Douglas, took his file and kept it on his desk for a very long period. And it is only as a result of the intervention of CARICOM that this matter was settled. Now, the reason why I have decided to use this case is because I've listened to all my colleagues, and let me just make it abundantly clear that the issue of reform is necessary. Let me just make it clear that when you look at all the legislation that is before us, we understand that Trinidad has more or less been the exception to the rule. And that is to say that having been sworn in as the Prime Minister, the existing legislation really gives you 100% of your salary as your pension. The recommended tier system of the government, in essence, I have no difficulty with. And the majority of us, I would say all of us, don't have a difficulty with the tier system. But let me also say that what we have a difficulty with is the retroactivity. Right? Similar to the government, we have listened to the public, and the public have given their utterances as to how they best feel, not only prime ministers, but whether it be ministers, whether it be MPs, whether it be councillors. We know in the public domain that these discussions have been taking place. We know that when we looked at the salaries review report, that it caused a lot of disturbance and upheaval in the society. And we also know that the impression that was given when that report was laid is that only the Prime Minister and the members of Parliament, particularly the ministers of the PNM government, the impression was given that those were the only persons who were getting increases in salary and back pay. And we know very well that when we look at the Salaries Review Commission report, it impacted on PSs, it impacted on the Leader of the Opposition, it impacted on all members of Parliament receiving their back pay. And Mr. Speaker, when you look recently at the debate for the supplementation, which we did last week, we know very well that it impacted on almost every single person who sat before, whether on this side or on that side. And I think, therefore, it's a bit disingenuous for there not to be an admission by the government that members of Parliament at that time would also be receiving a back pay. So, Mr. Speaker, I think like everybody else who wants to ensure that we give a good contribution to the debate, that we have done our research. I think it is fair to say that we all looked with great interest as to what happened in England last year in relation to, at the time, Richie Sunak, Elizabeth Truss, and saw the concern for a prime minister that served only 40+ days. And we understood the consequences to the then government of a situation like that. But we cannot pretend that the legislation didn't exist and doesn't exist at this time. Mr. Speaker, I must say to you that my main concern is that we have to be very careful that we do not walk a line that, notwithstanding the fact that a government may have a majority to do as it pleases, that they do not abuse their power. And I am very clear in my mind, because I made it very clear on my assumption as leader of the opposition, my willingness to support good law, my willingness to collaborate with the government. And I want to say that this is one instance where I will maintain my position. And it's getting clearer to me from listening to every member of the government that this is targeted against one person. As a matter of fact, the last speaker made it abundantly clear in his contribution that this bill is all about the Member of Parliament for Port-of-Spain North, St. Anne's West. St. Joseph. Now, Mr. Speaker, we have to ask ourselves, when you are making law and the Attorney General, I don't know if he's going to be part of the debate, but what I'm saying is that when you are making law, even if you take the position you don't like somebody, is it that you're going to make law specifically to target that person? Because it's... In other words, what you are doing is that, and whilst the Honorable Minister of Finance said that this bill is not being sinister, he said that it is based on a genuine need for reform. And every single parliament, every single government, every single country knows that it is absolutely necessary to do reform. And I'm making it clear that we support reform. But I'm making it clear that it is difficult to support when you come to the House and you said it is all about you and you and you alone. Dangerous. That we want to change legislation. Mr. Speaker, at the end of the day, I have to believe, regardless of what, that all of us in here, at the end of the day, want good legislation. Mr. Speaker, this bill, this Prime Minister's Pension Amendment Bill, as I said, seeks to amend the Prime Minister's Pension Act, Chapter 215 of the Laws of Trinidad and Tobago. And this is not a new law. As a matter of fact, and I think several speakers said it, it has been on our books since 1969, covering the service beginning since in 1962. Mr. Speaker, at its core, the Act exists to provide a pension and gratuity to persons who have served as Prime Minister of the Republic of Trinidad and Tobago, and not only that, to support their families. Now, I notice in the two-tier system, they make reference to the fact that if you do not serve a year, you are not entitled to pension. And I just want to suggest that it is a matter that we should look at a little closer. And why do I say that? I say it because when you look at the Parent Act, which needs to be said for the benefit of those who may be viewing or listening. It says, and if I might quote, every person who having been appointed a prime minister on or after the 31st day of August 1962 ceases at any time after such appointment to be a prime minister shall be paid a pension under this act with effect from the date on which he ceases to be the prime minister. And it is subject to subsection 2 of the pension, that the pension shall continue to be paid during the lifetime of that person. So, Mr. Speaker, in essence, you have the eligibility criteria. Ceases to be a prime minister, and the issue of the fact that it continues basically for the rest of the life. And I know that is where the concern is. And the simple issue we have to ask ourselves is why in bringing this legislation, we cannot say that this is from here on. Why is it so necessary to target an individual? Mr. Speaker, I want to suggest that similar to those on the other side, my colleagues on the other side, who have spoken about listening to people, I want to say that a number of the persons that I've spoken to see this legislation as being deliberately vindictive, revengeful, and wicked. And I heard the member for Sawa Barataria talking about if I'm defending my leader. I heard him. I just want to make sure, because in his contribution, he spoke about the fact that we are the weakest opposition. Let me just make it abundantly clear that we may be 13, but we are better than the 26 on the other side. You know, it have a statement called, we may be little, but we talawa. So, Mr. Speaker, there is a nuance, and Mr. Speaker, the nuance is, if the pension of a former prime minister is entitled and is greater than the salary they are currently earning as a legislator, they are allowed to collect the difference. Mr. Speaker, I was very happy that the Member of Parliament for Port of Spain South gave us the detailed information so that people could be clear that even during the period 2015 to 2025, when the Honorable Prime Minister was leader of the opposition, under the law, she would have been entitled to receive the salary or pension of a Prime Minister. Because, yes, she served 5 years. But if you do the research in many countries, if you are a sitting member of parliament and a leader of opposition, you will only get that pension after you retire as a prime minister. So Trinidad and Tobago, in many different ways, is an exception to the rule. And therefore, if we're doing reform, and they boasting about reform, then we must do total and absolute reform. And I also listened to my colleague again from Sawa Barataria, and I believe it was him, who made reference to the fact that there are a number of our colleagues, because elections was called earlier, including very recently, who would have been put in a predicament where they would not have received a pension. So that if we are really talking about reform, and I remember, the Honourable Member for Sawa Barataria raised the issue of senators. I have had the good fortune to sit as a senator, and I remember several senators, Louis Horn being an example, that served about 3 terms, and those persons were not ever entitled to a pension. So that it may very well be, Mr. Speaker, that this is a very good time for us not only to think about a particular person, but to think about other persons that this legislation is going to be impacted on. Because at the end of the day, when we go back to the Salaries Review Commission report, and I mean, there's a lot of discussions, and from time to time, ever so often, whether it's 5 years or 10 years, and some people tell you that they fall out of the loop. And we understand that, and I'm sure you would recall that many years ago, when they did a report, and I remember several judges, for example, Monica Barnes and others, were getting just a couple $100, and we had to review it. So that I am just recommending, and I'm hoping it's going to be there for the consideration at some point in time, that we honestly and very carefully consider that whilst we are attempting to treat with a situation involving one person, that we can do better and look at other situations. Mr. Speaker, if I could just say that Section 4.1 states that the Prime Minister's pension payable under this Act to any person shall be the full amount of the highest annual rate of salary paid to any person at such time as a Prime Minister. And, Mr. Speaker, what this means is that the pension itself is equal to the highest annual salary that the person received, but received while serving as a Prime Minister. Not an average, not a reduced amount, but the highest rate earned. This is also a very important part of the Act, as it stipulates, in effect, a defined benefit type of pension arrangement accruing to the Prime Minister. However, Section 4 also provides for the individual to have an option to choose a smaller annual pension, 3/4 of the full rate, in exchange for a lump sum gratuity. The gratuity is calculated as 12.5 times the amount that was deducted annually. So let us say, for argument's sake, Mr. Speaker, if tragically any former Prime Minister passes away before the pension is paid, but after leaving office, their estate still receives that same gratuity and reduced pension as if they had chosen the option themselves. That's the current law. Yes. Mr. Speaker, the Act also goes on to cover other details such as a widow benefits and benefits accruing to children in the case of their untimely passing of the death of a Prime Minister. However, I will focus on a discussion on mainly sections 3 and 4 of the Act, as these are the relevant sections which this proposed amendment seeks to alter. Mr. Speaker, I thought it important to briefly go through some of the important and relevant aspects of this Parent Act so we can appreciate the context under which we are having this discussion and this debate. So let me just say, because I think it's important for the public to be aware, this pension is not a bonus, it is not arbitrary, and it is not exclusive to anyone, meaning in any particular political party or any personality. It is a structural benefit crafted to uphold the dignity of the office, regardless of who occupies the office. And therefore, Mr. Speaker, that said, it is fair and healthy for us to debate the levels of such pension, whether they are sustainable, whether they should be performance-based, and of course, I think as we have all agreed, whether there is need for reform. But I want to suggest, Mr. Speaker, that in so doing, such debate must begin, of course, with an honest understanding of what the law actually says. So, Mr. Speaker, The current law, as I said, states that everyone appointed Prime Minister on the August 31st, 1962, and ceasing after such appointment to be Prime Minister, shall be paid a pension effective from the date on which they seal to hold the post, and the pension shall continue, as I said. Yes.
4:30. Your regular time ends at 4:36. I propose, if you don't intend to ask for your 15 minutes, that I allow you to finish and then we take the break. But if you do, we could take the break now. It's a matter entirely for you, subject to the other members of the House. But
Yeah, thank you kindly, Mr. Speaker. Yes, I intend to ask for my time.
okay, so let's take the break now and we come back at 5:15. Member for Arima.
Thank you kindly.
One more minutes.
Yeah,
if it accords with yours.
Yes, that's correct. That's correct. Thank you very much, Mr. Speaker. Mr. Speaker, so I was saying basically that as it relates to this amendment, we're really looking at the fact that, you know, the person is serving, well, must serve at least a year, and it's retroactive. Mr. Speaker, as it relates to the introduction of Clause 5 of the bill, which I want to deal with a bit, which proposes an amendment to Section 3 of the Act, I think that warrants a bit of consideration. The amendment stipulates that a person must serve a minimum of 1 year in the capacity of the Prime Minister from the date of the appointment. And this, in essence, seeks to align Trinidad and Tobago with countries like Canada as well as New Zealand. But in Canada, the individuals who have served as a Prime Minister can only receive a pension if they have served, interestingly enough, Mr. Speaker, 4 years. And as it relates to New Zealand, you can only receive a pension if you have served 2 years. So these are some examples. And Mr. Speaker, for the reform to be respected, I want to suggest that it therefore must be consistent and sustainable. It must respond to local realities while keeping in step with evolving norms elsewhere. Mr. Speaker, what is interesting is that the bill also introduces a new rule, and that is no pension would be paid, as I talked about, in relation to where you have served, where you haven't served at least for a year. Now, I just want to say that while some of my colleagues have mentioned it, I just want to give some further information that in Barbados, Jamaica, and Guyana, I know some colleagues mentioned Barbados, the Prime Minister is eligible for a pension the moment they leave office, regardless of how long they serve. If we look at India as an example, India has no set minimum period. The role of Prime Minister is treated with respect, and the pension reflects the significance of the office. The proposed one-year proposal may seem like a matter of simple arithmetic, but it has deeper implications. So if we look at other countries, Australia, New Zealand, Canada, and India, they link pension to the years of service, but they do so differently. And if I could just say, in India, members of parliament start receiving a pension immediately after leaving office and receive more if they served beyond 5 years. In Australia and New Zealand, politicians contribute to a pension scheme. And in UK, following reforms, the Prime Minister now earns pension rights gradually as part of a broader system for ministers. So these systems share two features. First, they must build up a pension value, and gradually. So let me just make it clear what this amendment is proposing. Above 1 year, 1/3 salary, 2 year half, above 3 years, 2/3, and above 4 years at 100%. But in Barbados and Jamaica, the figure is 2/3, and in Guyana, it is 7/8. So the key point is this: none of these countries offer the 100% pension even after the 4 years, and none of them offer 0 for any period of tenure either. So our amendment, therefore, has some sharp cutoffs where small differences in time lead to big differences in outcome. The Caribbean tradition, from what we can see in Barbados, Jamaica, and Guyana, does not therefore favor strict cutoffs. Our region has seen short-lived governments, unity coalitions, and transitional administrations. These are part of our democratic story. A pension system, therefore, has to acknowledge the reality. Mr. Speaker, there are two other issues that I want to deal with in relation to the bill that I don't think anybody has touched. And that has to do, I mentioned it earlier, that when one looks at the Parent Act, there are some issues of gender disparities that arise. If we look at Section 2 of the Act under the interpretation entitled child, an entitled child means a person who, being a male, has not attained the age of 21 years, or being female, has neither married while under the age of 21 years, nor attained the age of 21 years. And my question under this interpretation, there is a clear gender distinction and qualifying criteria for male versus female. A female is required to not only be under the age of 21, but also be unmarried in order to be an entitled child under this Act. And obviously, this is not a matter that seems to have been addressed. And as it relates to the widow's benefit, and I'm referring now to Section 5.1, where a person dies while he is entitled to receive a Prime Minister's pension, and he leaves a widow, the widow shall, subject to subsection 3, be paid a pension at an annual rate equivalent to 2/3 of the Prime Minister's pension that would have been payable to him had he otherwise ceased to hold office on the date of death. So we are therefore asking on this side, how is this section impacted by the qualifying criteria these amendments are now placing in section 4.1? What is the scenario if a prime minister dies within less than 1 year in office? We do have a few examples of this. How is his widow benefit impacted, if at all? Do these amendments now disqualify a widow from a pension entitlement in an unfortunate circumstance like this? Does it create confusion and ambiguity? Has this been contemplated? So I am looking forward to some sort of response as it relates to that matter. Mr. Speaker, I just want to recommend that, in my humble view, that this is a situation where we on this side believe that this bill is somewhat rushed, narrow, and premature. I would like to say that and ask my colleagues on the other side. There are two other institutions, President of the Republic and Chief Justice, and Mr. Speaker, if either the President or the Chief Justice serves 1 day, similar to the legislation that we are debating today, they would be entitled to the 100% pension. Now, if it is that this government is speaking about reform, and you have a similar situation with the President and the Chief Justice, where if you are appointed for 1 day in either of the positions, you get all the benefits. If they are speaking about reform, how it is that those two institutions, those two positions, are not being contemplated in the reform? So how is it, therefore, how can we in good conscience revise the entitlements of one office holder in a vacuum? Are we to say that the office of the Chief Justice, which safeguards our rule of laws, or the office of the President, which embodies our unity, doesn't warrant similar scrutiny or reform? Or is it that it is very possible that at some point in time, the government, with its majority, is going to come to the Parliament, if it is there is some difficulty, and make an amendment to deal with either of those two positions? Mr. Speaker, I want to suggest that, based on all the discussions that I've had and the recommendations, it is clear that a number of countries have dealt with these matters in many different ways. As I indicated, in New Zealand, the defined benefit pensions were abolished across the board in favor of universal retirement savings schemes with no special exceptions for prime ministers. Barbados, Jamaica, and Guyana reforms to the prime ministerial pensions are debated as part of a larger civil service or high office holder frameworks, and as I indicated, Barbados is doing their debate now as we speak. So my question is, why are we not moving with our regional and Commonwealth peers to craft a cohesive, forward-looking model that balances honoring public service with fiscal prudence? Mr. Speaker, the public perception, as I close, the public has stated in our interaction with them that this bill is politically motivated, poorly timed, and, as I indicated, targeted against one person. Until we address the offset rules that govern whether a person can draw a pension while serving in public office, and until we apply reform prospectively and not retrospectively, I am saying that we on this side have a difficulty. I have made it abundantly clear, and I have gone through the recommendations of the government as it relates to the reform, and I'm saying that in principle, we agree there is need for reform. But I'm maintaining my position that the issue of targeting one individual and retrospective legislation is not a good idea. We are therefore calling upon the government today, as I bring my contribution to an end, to remove this offensive retroactive clause from the bill for the good of our democracy, and work with the opposition on a proposal for the tiered system so we can deal with a lacuna in the law. So I do not want it to be said that we are not in favor of the reform. We stand, our position is that the government should address the issue of the retrospective legislation. Thank you, Mr. Speaker.
Honorable Attorney General.
Mr. Speaker, I rise to close the debate this evening. The Minister of Finance is unavoidably absent. Now, I acknowledge the fact that this evening the Leader of the Opposition has expressed qualified support for the legislation. She said that she had a problem, if I heard her correctly, only with its retrospectivity, not with the tiered system that we seek to introduce. Now that is some progress, because what she acknowledges is that she has no problem with the bill insofar as it states a period of time for qualification to pension, and that is progress. It is a recognition that what obtains in the law now, that is the absence of a period of time, is enhanced by our proposals for reform. And that is a recognition that the present legislation is not ideal. Two questions are necessary. Why is that, and what can we do about it? Now, if she concedes that the existing law is unique and that in other Caribbean territories pensions are given largely on the basis of tiered service, that is to say more pension, more service, more pension, and the converse, of course, is true. That's not rocket science. It's common sense logic. Most people would appreciate that you are paid for what you have done, and pension is a form of deferred payment. And they'll also understand that there's no such thing, Mr. Speaker, as a free lunch. So you are paid a pension because you have served. And the converse is true. If you have not served, then you either get no pension or less pension. Now, if I understand the contribution of the member correctly, what she is saying is that she has a problem with the bill's retrospectivity. And we have two answers to that. The first is a general one. If you recognize at some time that there's a problem, a legislative problem, we say on this side, you have a duty to fix it. And that is to say, if at any time you recognize that there's a problem, you have a duty then to fix it. And the second is another rule of common sense. If you made a mistake, you have a duty to make that mistake right. And we recognize that our friends opposite would have erred when they enacted the relevant provisions. The leader of the opposition concedes that the principle of our amendment is sound. And what we say is that we are going to fix it. And the only way that one can fix it with integrity in the present circumstances, Mr. Speaker, is if you do so with an element of retrospectivity. And, Mr. Speaker, there are general principles and there are cases which establish that there is nothing which is constitutionally unsound in retrospective legislation. So, if you look at, for example, and I'm not opening up the debate again, if you look at what the authors of the general text, Nyan, say on retrospective legislation, they say that it is important to grasp the true nature of objectionable retrospectivity. Objectionable retrospectivity occurs where the past legal effect of an act or omission is retroactively altered by a later change in the law. But the mere fact that a change is operative with regard to past events does not mean that it is objectionably retrospective. And we say that that is what we are doing. We are making a change. That change would have an effect in the past, but that is not in itself enough to say that it's objectionable. Now, the cases, and there are a couple that I think are relevant. There's Surratt and the Attorney General of Trinidad and Tobago, and Ferguson versus the Attorney General of Trinidad and Tobago. Surratt is general principle, Ferguson is on the removal of an accrued right. And what those cases do, Mr. Speaker, is to establish some general principles. They say in Surratt, for example, that ordinary legislative activity would, by its very nature, invariably affect constitutional rights, but that effective governance in the national interest might require that a balance be struck between the public interest and individual rights. And we say that that is what is taking place here this afternoon. We have a duty to protect the public interest, even as we recognize that in doing so, we might affect individual rights. Mr. Speaker, the bill before us this afternoon has a legitimate aim. There is a relationship, a reasonable relationship between that legitimate aim of the law to make a non-objective alteration of the law with respect to past events and the measure which is before the House. I commend the bill to the House, and with those words, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251, be now read a second time. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251.
Leader.
Mr. Speaker, our friends opposite in the opposition have asked for a 10-minute suspension so that their members can caucus. So we have agreed for such.
Okay. In accordance with the agreement reached on both sides, the House is now suspended for 10 minutes. We start at 4:36. We resume at 5:36. Honorable Attorney General.
Mr. Speaker, in accordance with Standing Order 68-1, I beg to move that the Prime Minister's Pension Amendment Bill 2025 be committed to the Committee of the Whole to be considered clause by clause.
Honorable members, the question is that the Prime Minister's Pension Amendment Bill 2025 be committed to the Committee of the Whole to be considered clause by clause. Those in favor say aye. Aye. Those against say no. The ayes have it. The House shall now go into the Committee of the Whole to consider the bill clause by clause.
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 1 now stands part of the bill.
Clause 2.
Mr. Chairman, relative to clause 2, we are suggesting to the Honorable Attorney General that this clause be deleted because of our position on the nature of the clause, please.
Mr. Chairman, is there a circulated amendment or are these amendments on the floor? As I know the procedure in this House is that we would only consider these amendments if circulated.
Mr. Chairman, when one wants to delete an entire clause, is it necessary to circulate that?
Yes.
You don't understand English?
Yes. Yes.
I'm reminded by the clerk who knows this far better than I ever can or will. And what I'm advised is that the proposed amendment ought to have been circulated, it ought to be in writing. So no clause, proposed amendment in writing and has not been circulated. So I'm not going to entertain that. So the question is that clause 2 stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. I think clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. The question is that clause 3 now stands part of the bill. Those in favor say aye. Aye. Those against say no. No. The ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that Clause 4 stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that Clause 5 now stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 5 now stands part of the bill.
5, sorry. Clause 6.
The question is that Clause 6 now stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 6 now stands part of the bill.
The preamble.
The question is that the preamble to the bill be added. Be approved. Those in favor say aye. Aye. Those against say no. The ayes have it. The preamble is hereby approved. Members, the question is that the Prime Minister's Pension Amendment Bill 2025 be now reported to the House. Those in favor say aye. Aye. Those against say no. The ayes have it. The bill will now be reported to the House. Attorney General.
Mr. Speaker, I wish to report that the Prime Minister's Pension Amendment Bill 2025 was considered in the Committee of the Whole and approved without amendment. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Prime Minister's Pension Amendment Bill 2025. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251, be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. This bill requires a 3/5 majority.
Mr. Padareth?
Yes.
Mrs. Prasad Bisasa?
Yes.
Ms. John?
Yes.
Dr. Munilal?
Yes.
Mr. Lee?
Yes.
Mr. Hosein?
Yes.
Ms. Amin?
Yes.
Mr. Alexander?
Yes.
Mr. Maharaj?
Yes.
Ms. Mohit?
Yes.
Mr. Sturge?
Yes.
Dr. Bodoe?
Yes.
Dr. Dowla?
Yes.
Dr. Ali?
Yes.
Mr. Morris?
Yes.
Ms. Benjamin?
Yes.
Mr. Sobers?
Yes.
Mr. Watts?
Yes.
Dr. Sicharan?
Yes.
Mr. Kisa?
Yes.
Mr. Elder?
Yes.
Mrs. Sam,
Yes.
Mr. Narayan Singh,
Yes.
Dr. Roop Narayan,
Yes.
Dr. Hosein,
Yes.
Mr. Thomas,
Yes.
Mr. Sampson,
Yes.
Mr. Gonzalez,
Abstain.
Mrs. Beckles-Robinson, Mr. Imbert,
Abstain.
Dr. Gadsby-Dolly,
Abstain.
Mr. Scotland,
Abstain.
Mr. De Nobrega,
Abstain.
Mr. Manning,
Abstain.
Mr. Marcel,
Abstain.
Mr. Devines,
Abstain.
Mr. Birchwood,
Abstain.
Mr. Romaine,
Abstain.
Mr. Speaker, the result of the division is 27 members voting in favor of and 11 members abstaining.
Honorable members, with a division of 27 members voting for and 11 abstentions, the motion for the third reading of the Prime Minister's Pension Amendment Bill 2025 is approved.
A bill entitled, An Act to Amend the Prime Minister's Pension Act, Chapter 251. Motions.
Minister of Health.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Children's Life Fund, Amendment Bill 2025, listed in the appendix be now considered.
Honorable members, the question is that the Senate amendments to the Children's Life Fund Amendment Bill 2025 listed in appendix be now considered. All in favor say aye. Any against? The ayes have it.
Clause 2A. Delete the proposed definition of lifetime illness and substitute the following definition. Life-limiting illness means an illness or condition listed in Schedule 3. 6A, Clause 6A. Delete Clause 6A. Clause 7, in the proposed Schedule 3A, in the heading, insert after the word illnesses the words or conditions. B, under the subheading Pediatric Surgery, delete the item liver transplant and substitute the item liver failure. C, under the subheading Nephrology, delete the item kidney transplant patients and substitute the item end-stage renal disease or advanced chronic kidney disease. D, under the subheading Endocrinology, delete the item congenital hyperinsulinemia for chronomatic cytoma and substitute the following items: congenital hyperinsulinemia or for chronomatic cytoma.
Mr. Speaker, I beg to move that this House agree with the Senate in the amendments to clauses 2A, 6A, and 7 of the Children's Life Fund Amendment Bill 2025. Mr. Speaker, the government has noted the enthusiasm with which the Children's Life Fund Amendment Bill 2025 was debated in the other place on Monday of this week. Today, I bring to this House the results of those deliberations in the Senate in the form of 3 amendments. Mr. Speaker, it is to be noted that these amendments have no significant impact on the scope or policy change originally intended when this bill was first brought to this House a few days ago. As such, Mr. Speaker, the government has no problem in accepting the amendments before us. Mr. Speaker, it is to be noted that this Children's Life Fund Amendment Bill also generated considerable public interest and excitement as the public understood that this, the first legislative measure undertaken by this government, led by Prime Minister Kamla Prasad Bisesa, will increase, expand, and expedite the services available to the most vulnerable in our society, that is, our children with life-limiting illnesses. Mr. Speaker, this was the Honourable Prime Minister's way of signaling to the population of Trinidad and Tobago that this government's priorities were aligned to helping those most in need of help, not only today, but also going forward. Mr. Speaker, I take this opportunity to thank all colleagues who contributed to this debate in the other place, all of whom agreed in principle with what was being proposed in this long overdue amendment of the Children's Life Fund Act 2010. I note that many of the issues raised in the debate were very satisfactorily addressed by my colleagues in the Senate. As a result, Mr. Speaker, we have what should be a very simple task before us today of approving these 3 amendments. This will allow the Children's Life Fund Authority Board and the Children's Life Fund to now consider a wider range of conditions for which applications can be considered. I refer to the new Schedule 3. Additionally, in keeping with increasing cost of medical treatment, the limit has been increased from 1 million to 1.5 million as required. So, Mr. Speaker, the amended Act also empowers the Minister in certain circumstances to review denied applications, an option that was not available to citizens previously. Mr. Speaker, let me put on record my gratitude as Minister of Health to the numerous persons who would have served either on the boards or as clinical experts over the years, and also my thanks to the staff at the Ministry of Health and the Children's Life Fund Board who would have assisted in bringing forth these amendments. So, Mr. Speaker, really it is left up to me now to speak to the amendments very briefly. And of course, Clause 2A, as mentioned, is to just to change the definition of life-limiting illness. 6A is very simple to delete Clause 6A. And Clause 7, Mr. Speaker, and I will just refer to the last item, and I want to commend the clerk for a very close pronunciation of the medical terms, but just for the record. So we have 7A, 7B, 7C, and I refer to 7D under the subheading endocrinology, which we are now deleting the term congenital. Actually, it's just a separation, and so it's just really a grammatical correction here, so where we are separating congenital hyperinsulinemia and from pheochromocytoma. So, Mr. Speaker, with those few words, I again signal the intention of the government to accept these amendments, and I beg to move, Mr. Speaker.
Honourable members, the question is that this House agree with the Senate in the amendments to clauses 2A, 6A, and 7 of the Children's Life Fund Amendment Bill 2025. Member for St. Anne's East.
Thank you very kindly, Mr. Speaker. Mr. Speaker, the Senate amendments enhance the definition of the life-limiting illness with more accurate medical terminology, and that really crystallized the meaning of life-limiting illness. I think it really shows the strength of the bicameral system that we have, because it allowed citizens to contribute to the the bill in a way that really strengthened it and allows the members of the independent bench as well to, as well as the PNM opposition in the Senate, to enhance the bill. So the PNM bench, I want to note that in the lower house we did question the definition, and although those questions and those changes were not accepted in the House, the Senate amendments really vindicate the PNM's position regarding this matter. And in that light, Mr. Speaker, we are happy to accept the amendments and support.
Minister of Health.
Thank you, Mr. Speaker. So, Mr. Speaker, as I mentioned, we were indeed grateful for the contributions made by colleagues in the Senate, but of course to again emphasize that the intention of this bill really was to expand and increase the number of conditions that were available that the children will now be able to benefit from. So, Mr. Speaker, I don't think I need to go into any further detail. I think it's very clear. And the fact being that the government has achieved what it intends to achieve, really for the benefit of the children of the nation. And so, Mr. Speaker, with those few words, I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to the children, in the amendments to clauses 2A, 6A, and 7 of the Children's Life Fund Amendment Bill 2025. All in favor say aye. Aye. Any against? The ayes have it. Leader of Government Business.
Mr. Speaker, I beg to move that this House do now adjourn to a date to be fixed.
Honourable members, the question is that this House do now adjourn to a date to be fixed. Those in favour say aye. Aye. Any against? The ayes have it. This House now stands adjourned to a date to be fixed.